The appeal stands dismissed and the judgment for the renunciation will be valid.
And we also participate in bidders lots. We participate in the bid process, but there are anomalies which are very glaring, which we pointed out in the repetition slots.
Tomorrow. I might have a problem tomorrow. Already we have fixed certain. When they already been selected,
Lordship.
only work order has been issued. What is the
Work order has not been issued, Lordship. Only the letter of award was issued. Work order will be issued as per the template. And only difficulty is like our work is until 30th, Lordship. And
Huh? Work is under?
the work that we are continuing to do right now is up to 30th of this month. And we also participated in the bid process. However, this is very glaring and
What is this? With what? With regard to what? Fishery? What?
Lordship, with collection of garbage in the city of Guwahati, Lordship, issued by the Guwahati Municipality Corporation. The person who has L1 and who's been awarded the
Your contract has been terminated
no,
when?
not terminated, Lordship. We are continuing because the period will get over for the contract period. However, the
Contract period will get over on 30th. Then what is your right?
Lordship, we had to participate in the bid process. The L1 who was awarded the contract has relied on documents which are apparently not the entity is a different entity for which they are given the credentials, Lordship, which is very apparent on the record, Lordship. The credentials which
Monday. Monday the 30th. Nothing will happen. Because they cannot tell him to start work from the time till the time your contract is in valid. Your contract is valid till 30th.
Lordship, we'll be continuing to work.
Yeah, 30th.
Obliged.
Made please, Lordship. Lordship, with the consent of the petitioner.
Otherwise, if you want, nothing will happen. I think if you want, we can do it today. Today at 2 o'clock.
Lordship, it's voluminous, so it may not be exactly 4 o'clock, Lordship. Like
You have not filed it as yet.
Lordship, we can take. It has to be reported, Lordship. We have filed it yesterday.
It has to be. What is what? Acha. Monday one.
Obliged.
Made please, Lordship. With the consent of the other side, I beg to mention item number 12, Lordship. That matter may come up after vacation, Lordship, puja vacation.
What is the matter about?
Lordship, this matter is related to service, I suppose. I am not familiar with the
What is your name?
Lordship, my name. C. Sharma, Lordship.
C. Sharma appearing on behalf of
Water Resource Department.
Water Resource Department, prays for adjournment and submits that has taken the consent of the other side.
Yes, Lordship.
Accordingly, leave this matter after the vacation.
But I have to mention one, matter to be listed for tomorrow, with the eviction matter, and on third.
Eviction. Page 5.
Please, your lordship, I beg to mention a writ petition for listing on Monday. Lordship, it is a tender matter. My work order has been cancelled in the last month. And my money also, security amount also has been fortified. And I'm not allowed,
Forfeited.
forfeited, and I'm not allowed to continue the work. Monday,
Okay, Monday, no problem.
Monday. Public.
May Lordship, I beg to mention for listing tomorrow matter one land eviction matter.
Eviction, page 5.
May I please, your lordship, I beg to mention item number 5, we are led by senior advocate R.P. Kakoti. He has some personal inconvenience today, so any date may be fixed after vacation, your lordship.
2016 matter, Mr. Council. Let us see the item 6, item 5.
Item 5.
Last date also it has been adjourned on your behalf, petition behalf. Correct. Adjournment prayer has been made on behalf of Mr. R.P. Kakoti, Lance R.P. for the petition. So it is also noticed that on the last date, the case has been adjourned on the prayer made on behalf of the petition. Okay. This matter. Is there a stay order? There is a stay order. It is also noticed that there is a stay order in this case, which had been issued on 24/8/2016. This is the matter after the vacation. No adjournment shall be provided on the next date.
Please, your lordship, I beg to mention for listing of WPC 2924 admission, lordship.
When?
Next week, any date, lordship.
Next week is motion week. That is the problem. Anyway.
Item 13 for motion. Maybe lordship, it's a tender matter, lordship. And the petitioner and respondent number 5 both participate in the tender process. I am referring the petition at page 6, para 6, lordship.
Page?
Page 6, para 6.
Yes.
That respondent number 5 was declared as the first bid, and the petitioner was declared to be the second bidder, lordship. And lordship, I am directly in reference to.
Huh?
Again, I am referring the page, para 8, lordship, para 8. I'm just reading it, your lordship. That the petitioner could know from the reliable source that the.
No, this will not do. You have to give specific.
Yes, specific lordship, that is last 2 line, that para 8, last further.
Yes.
Further. This is the important lordship.
Yes.
Further, the petitioner submitted that the respondent number 5 has participated in another tender process of so and so. And though the respondent number 5 was the highest bidder, but he has withdrawn his tender after opening the financial bid. So the tender committee of the respondent authority decided to forfeit his earnest money deposited with the tender, and he has been prohibited from the submitting any tender in IWT for continuous period of 4 years, that is 2024, 25, 26, and 25, as per clause 16 of NIT. Even then, such disqualification, the respondent number 5 awarded with the tender for leasing out the ferry service at so and so, so and so.
Mr. Council,
That's-
please answer this question. The ferry service at Baralimari, Kadwa,
That's it.
was based on the NIT dated. NIT dated
Lordship, NIT there are, Annexure A, Lordship, page 13.
Yes, what is the date?
Yes. That is, Your Honor, 8 to 24.
8 to 24.
Yes.
So this this he has been given. He has been given this, he has been given the ferry service for in person to this NIT, correct?
Lordship, there are 23 numbers of ferry service in this NIT.
Okay, in this NIT he
Yes,
has
I have
been.
applied for only one.
I'm not talking about you, I'm talking about the respondent number 5.
Yes, respondent number 5.
Respondent number 5
Yes,
has applied for number 4 and 5, correct?
Lordship,
So 5 he has been given.
5 has been given.
Now 4 he has not been given. But now before in 4 that penalty was imposed, correct? Now what is the penalty?
The penalty, Lordship,
At
I'm
page
56.
56.
Yes, minus.
Now page 56 says what?
Yes. One bidder.
Yes.
Yes, one bidder, Usman Ali.
So he decides to forfeit his earnest money
Yes,
and the tender has been prohibited from submitting any tender for a continuous period of 4 years. So this order was issued on, this minute was made on 28/6.
28/6, Lordship.
So what do you understand by this penalty? That means from 28/6, 2024, he cannot participate in any future tender. That's all. It does not talk about the past tender.
That is the same tender, Your Lordship. There is 24, 25, 26, the 4 years. he has been-
Maybe, but then it has to relate to a certain period. The penalty is imposed, supposing the penalty is imposed upon you today. Supposing the bar council tells you that you cannot practice for anymore for 4 years. Can it start from from around 10 years back or 4 years back or 20 years back? From when? It'll start from the day the order was issued. Now the order was issued on 26/4. No, on 28/6, sorry, 28/6/24. When it is issued on 28/6/24, that order will be effective with respect to actions to be taken from 28/6/24, not past actions.
Apart from that, Lordship, here, he has not, he did not comply the necessary dictionary, Lordship, page.
What?
Para 9, I'm coming.
Para 9, okay.
Para 9.
Para 9.
That pertinently mentioned here, apart from above disqualification, the respondent number 5 has not submitted NOC from the co-operator tender.
What NOC? Have you submitted any representation to the authorities? Have you submitted any representation to the authorities?
Not yet, Lordship.
You first go there, then you come here.
Lordship.
Okay.
In fact, Lordship, page 17, the tender condition, clause 16 is very clear, my lord.
Page 17.
Page 17, clause number 16 of the NIT.
Yes.
May I read, my lord? On
Yes.
scrutiny and finalization of valid tenders, withdrawal of tender by any participant will attract not
Ah,
only forfeiture PMD, but
from
the
future
same person. Yes,
participation.
my lord,
That's why from future participation,
yes,
not from the ones that he's already been
participated.
participated in. It's only from future.
Sir. I will dismiss this case.
No case out there, correct?
My lord.
So what to do? You withdraw or I dismiss?
Allow me to file representation before the authority.
Mr.
Ji Kakot.
G. Kakoti, Learned Counsel for the petition, submits that the petitioner that the respondent number 5 had participated in the tender notice dated 8/2/2024 issued by the Inland Water Transport Division for leasing out ferry services. Full stop. The respondent number 4 had participated, submitted his bid.
Was it five? As one of-
Respondent number 5 had submitted his bid for the Jerry Maria Chashila via Serang and Barali Mari. It's 4 and 5, at page 13. Ferry service. Full stop. Next paragraph. The petitioner's counsel submits that the petitioner was that the respondent number 5 was the highest bidder for the serial number 5, for serial number 5, while the petitioner was the second highest bidder. Full stop. The state respondents, however, settled the ferry service number 5, with the respondent number 5, even though the respondent number 5 had not submitted NOC from co-patadars and the tender documents were not self-attested. Full stop. Next paragraph. The counsel for the petitioner further submits that the respondent number 5 was also the highest bidder for the ferry service number 4. However, as the respondent number 5 had withdrawn his tender, the state respondent where is that order?
Lordship annexed E,
Just where is the punishment given, where is the penalty given?
56, my lord.
Had
55.
Relevant portion is
debarred and had prohibited the petitioner from, no, there's point number 5, from submitting any tender issued by the Inland Water Transport Department for a continuous period of 4 years, that is for the calendar years 2024 to 2027, as per clause 16 of the NIT. Full stop. Further, the respondent number 5 had also deposited his tender and his earnest money pursuant to the withdrawal of his bid in respect of the ferry service number 4. Full stop. The petitioner's counsel submits that as the respondent number 5 had been prohibited from submitting any tender with the Inland Water Transport for a continuous period of 4 years in terms of clause 16 of the NIT, the state respondents could not have settled the ferry service number 5 with the respondent number. Full stop. Next paragraph. Ms. M.D. Bora, the learned Standing Council Transport Department, submits that clause 16 of the NIT
page 17.
prohibits would prohibit the respondent number 5 from participating in any future tender issued by the IWT for a period of 4 consecutive years. She also submits that no specifics have been given as to the allegation made by the petitioner that the respondent number 5 could not have been given could not have been settled with the ferry service number 5. He further submits that the petitioner has not approached the state respondents with his grievance prior to approaching this writ petition. As such, The writ petition should be dismissed as there is an alternative remedy available. Mr. G. Kakoti, learned counsel for the petitioner, at this stage submits that he may be allowed to withdraw the writ petition with liberty being given to him to approach the authorities by filing an appropriate representation. The prayer of the petitioner's counsel is allowed. Writ petition is dismissed as withdrawn, with liberty to approach the state respondents by way of a representation. In the event the petitioner submits a representation, the same should be disposed of expeditiously by the state respondent.
Lordship. Deeply obliged, my lord.
What is the exact amount? What is the exact amount payable to the petitioner?
The instruction I received, Lordship, it says, Lordship, with reference to subject, the remaining bill amount of 11 lakhs and so is pending for, we have sent the proposal to the finance department.
So if that is there, then we'll close it with that. Enough.
I have also received a calculation with my details, Lordship, 11 lakh 32,000.
11 lakh 37
Yes.
023.
Lordship.
So this is more than what you have asked. Your claim is for 11 lakh 33,000.
That was my calculation according to me, Lordship, that there will be authority, they know appropriate, Lordship.
Then for the difference, you should buy laddus for everyone here.
Lordship.
Puja is also
Yes,
coming.
ma'am.
Right. Heard Mr. J. Abbas, learned counsel for the petitioner. Also heard Mr. S.K. Roy, S.S. Roy,
Yes, yes, sir.
learned counsel for
1, 2, 3, and 6,
What?
and 7.
1, 2, 3, and 7. Mr.
Here, Gogoi, Lordship, I am for 4, 5, and 6.
4, 5. The petitioner's case is that the petitioner had undertaken the contract work for construction of an RCC gallery under the project work development of Bara Pujia Anchalik Krida Santhar Khel Pathar at Bara Pujia in Morigaon district. The petitioner, on completion of the work, submitted his final bill amounting to rupees 1,36,37,023. Though the petitioner had been paid 3,63,57,000, the outstanding balance amount of rupees 1,36,37,023 has not been paid to the petition. Mr. S.S. Roy, learned counsel for the respondents number 1, 2, 3, and 7. Submits that as per the letter number SYW 55/2019/85 dated 23/9/2014, issued by the Joint Secretary to the Government of Assam, Sports and Youth Department, Sports and Youth Welfare Department. The petitioner is to be, the balance amount payable to the petitioner is rupees 11.37023 lakhs. Any submission on your part? Nothing, no? Okay. Okay. Mr. A.R.
T.R. Gogoi.
A.R. Gogoi submits that. In terms of the affidavit in the position filed by the respondents number 4 to 6.
4, 5 and 6.
4 to 6 means 4, 5 and 6.
Lot.
On 10/9/2024.
Lot.
Comma. A completion certificate of the work contract was submitted to the Director, Sports and Youth Welfare, Assam, for release of the fourth and final bill amounting to rupees 1,36,37,023. By letter number ASHB/CONS/2015/173/2421 dated 8/9/2017. Para 7, page 48. Yes. As can be seen from the, no, I have heard the counsel for the party. Next paragraph. As can be seen from the submission made by the counsel for the party, there is no dispute with the fact that the petitioner has not been paid his contractual bills in full. While it is the case of the petitioner that, while it is the case of the petitioner and the respondents number 3 to 6, that the petitioner is to be paid rupees 1,36,37,023. The respondent number the case of the respondent number 1, 2, and 3 is that the petitioner is to be paid rupees 11,37,023. In view of the fact that this court is of the view that as it is an admitted fact by the respondents number 3 to 6 that the petitioner is liable to be paid rupees 1,36,37,023, as has been claimed by the petitioner. The said amount should be paid to the petitioner as it is an admitted amount. So accordingly, accordingly, the respondents are directed to pay to the petitioner the outstanding amount of rupees 1,36,37,023 within a period of
3 months.
within a period of 3 months from the date of receipt of a certified copy of this order. Next, the letter number SYW 55/2019/85 dated 23/9/2024 issued by the Joint Secretary to the Government of Assam, Sports and Youth Welfare Department, is made a part of the record and marked as Annexure X. The writ petition is accordingly allowed.
Lordship, total now balance amount is only 11 lakhs, Lordship.
Oh, sorry.
Lordship is the one.
Okay, yes. Why didn't you tell me before?
Lordship, Lordship, in the midst of.
Because I was so, okay, please go back. To him. Just read from the beginning. Whole order. Okay, I'll correct it later.
It will be 11,
So I will give
11 lakhs.
11 lakhs, the claim you have paid. 11 lakhs, we'll give 11 lakhs 37,023. Oblige, ma'am.
Otherwise,
Yes, otherwise he'll become a crorepati due to mistake of the court.
This matter, Lordship, pertaining to the GST regime laws. His work order received before the GST regime. And he submitted one running bills before the GST regime and subsequent after the GST regime. So Lordship, this petitioner's claim is that he should be taken under the VAT Lordship, the earlier the tax rate laws. And that is the matter.
We, in our affidavit, my lord, in paragraph 9, my lord, we have clearly stated, my lord, that the bill claim, my lord, prior to, my lord, GST will be, my lord, under GST, my lord, VAT, and then after the 1/7/2017, it will be, my lord, as per GST. And as they will say stated that. Para 9 of our affidavit, my lord.
Otherwise, Lordship, the issue has been settled by the Honorable Court laws. I have given the judgment laws.
Wait, just a minute.
My lord.
So your case is that only the VAT portion should be deducted. CGST and GST cannot, state GST cannot be. So what is your case? Your case is that?
My lord, since, my lord, in case of work contract which were partially executed on or before, my lord, 36/2017, that is during that period, and that.
Where are we reading that?
My lord, that, may I read the paragraph 9, my lord?
Yes,
Which is our case, my lord. That 11 to 23, the dependent makes to say the entire second running bill amounting to rupees 33,71,620, certain such rupees, previous bill 22, and against all the work done by the contractor up to date was paid to contractor on 1/2/2019 by the Director of Fisheries through RTGS. It may be stated that the time period of completion of work was 6 months. Thus, the contractor had to complete the work by 15/9/2016 since handover of the site, that is 16/3/2016. However, the work could not be completed in the specified time frame for various reasons for which deducted of Deduction of GST in lieu of VAT has to be made from his bill as per the following government norms. In the meantime, Commissioner of Taxes Assam has issued circular number such as during deduction of GST for work. Accordingly, as per clause A, works contract, C, works contract partially executed on or before 36/2017 during VAT period, and the balance work being executed on or after 1/7/2017 during GST regime. In case of work contract which were partially executed on or before 36/17 during that period, there can be two situations. Bills, invoices were raised before GST. TDS will be made as per the provision of the VAT Act, and bills, invoices were raised after GST. TDS will be made as per provision of GST Act. In case of the works contract which were partially executed on or after 1/7/2017 during GST period, and invoices are raised during GST regime and payments are received during GST period, since the transaction was not accounted for under VAT, TDS will be made as per provision of GST Act. Complying with the above norms of Government of Assam, the Director of Fisheries has deducted GST, CGST 1%, GST 1% and CGST 1%. In case of second running bill of rupees 33,71,620 and third running bill of 30,12,380 for the works executed on or after 1/7/2017 only. But in case of first running bill, the director had already deducted VAT only, rupees 63,84,000 for the works executed on or before 36/17. It may be stated that the contractor, after running 70% progress, has again paused the work for second time since 27th of February 2019 to 7 December 2019. The contractor is still working but not yet completed the work as on date. They are complained that the deduction was 12% GST. It is wrong, my lord. Only 2% GST, 1% CGST and 1% SGST has been deducted. So, my lord, this is our case.
My case is that lordship, the first running bill was deducted as per VAT 5% lordship.
You were supposed to complete the work within what period? What is the time period for completion of the work?
The delay I have explained in the petition and
Let answer the question first. I'm not asking you
in the
what you
meantime, I
wore
have-
for Christmas or
completed.
puja. I'm asking you, did you go to the puja? That's all, just like that.
In the meantime, I have completed lordship during the pendency of the case lordship. And my first running bill was deducted as per VAT lordship, and second running bill and final running bill as per the GST Act.
When were you supposed to complete the work? How much, what was the time period?
That was only 6 months lordship.
6 months.
6
And work was started when?
Work was started on lordship
2015,
15 or
16.
16 because lordship the
Site was handed over on
handed over
16/3
16 lordship.
and he was supposed to complete on 15/9/2016.
But I have.
So what is the judgment? How does it
Judgment
help?
say that if lordship bill has been raised before this 36/2017, that in that case that has to be deducted, and if after that,
If after that.
then it will come.
So
under
your,
GST.
after which date?
After lordship,
1/7/17.
on or before, after 1/7.
1/7/17.
Yes.
Then it will come under GST.
Then your bills
My bills is first bill.
Bill
was
before?
And accordingly paid,
Ah.
and second bill was after accordingly. That's my case.
That's why, see, then this judgment does not help you.
Help him. And my lord,
Only help you, help me because lordship, there is a the honorable court has directed to file representation, seeking the
my lord, we
reimbursement.
have
If
clearly stated that, but in case of first running bill, the director had already
Lordship,
deducted
kindly
VAT
sit
only.
Ah,
First running bill VAT
correct.
deducted. my lord.
No, so, no,
No case, my lord.
no, that's what, no.
after passing of this judgment, I have no claim.
Yeah,
pending.
so in this case, you've got no
Oh.
case.
Yes.
So that's what they're saying. Oh, I thought you said that this case was supporting you.
But not supporting, but para 56 lordship, may kindly see lordship. I
Oh.
can submit a representation claiming that reimbursement if I am entitled. Yes, as per the-
He can always, my lord.
But you have come here.
Yes, my
Now
lord.
we cannot send you there.
If
When,
any-
when the judgment is against you, then what remains?
Only my favor is that I can submit a representation because terms of contract has to be seen. And
That,
terms of
that,
contract-
when you submit, we are not
That
going to
is the
say
end of the
anything.
respondent lordship.
We have already done as per this judgment, and my lord. judgment, but the first running bill only, that has been deducted, my lord.
After passing of this judgment, I have no claim regarding.
No right, no right, no case.
No, but
Okay, then we close it.
Lordship may only may observation that I can submit a representation as per this.
He can always approach, but for that, because in this case,
Because
there is nothing remained, my
Otherwise,
lord.
Lordship, it closed on the ground that the respondent will not take it in representation law.
Okay, right. Third, Mr.
Jay Abbas.
J. Abbas, learned counsel for the petitioner, as well as Ms. Udas, learned counsel for the,
All,
for all the respondents.
no, my lord, except, sorry, my lord, sorry, my lord. 3 and 4,
Or-
except 3 and
Except 3 and 4. The petitioner's case is that the petitioner had participated in a tender process for construction of wholesale fish markets in the districts of Dhubri, Barpeta, Hailakandi, and Golpara in the state of Assam.
My case was specifically for Goalpara Lordship.
First off. The petitioner had submitted his bid price of rupees 2,32,14,600 for construction of the wholesale fish market only in respect to Golpara district. Being the highest bidder. Being the highest bidder.
No, it will be lowest.
Being
Lordship.
the lowest bidder.
Typically.
Being the lowest bidder. The petitioner's tender was accepted and he was allotted the contract work. The petitioner's grievance is that while no, his grievance is that that while the NIT had been issued at the time the value added tax, correct?
Yes.
yes,
Which year?
Valuated here, valuated tax Lordship under the 2003 Act Lordship.
Under what act?
2003 Act Lordship in the judgment.
Where is that?
Lordship will find it page 10 of the judgment, Lordship, in the first paragraph itself, Lordship. Assam Valuated Tax Act 2003.
What about that? Value added tax act, 2003. Hereinafter referred to as the 2003 act. Was in force, comma. The petitioner second and third running bill have been given to the, have been released to the petitioner in terms of the Assam Goods and Services Tax Act, 2017.
As well as CDS.
Huh?
As well as
double page. That's what I was-
state and section.
Huh?
Second and third lot.
What?
Second, in the second and third bill, Lordship, it takes it deducted from as per Assam Goods Service Center and also CGS, Central Goods Service.
State and city.
That's what I said. What I said? Goods and Services Tax Act, 2017. Hereinafter referred to as the SGST and the
CGS.
Central uh, Goods and Service Tax Act. Hereinafter referred to as the CGS. The Central Goods and Service Tax Act is what is the year? Same year,
Same year.
2017, huh? CGS.
Can refer from the same.
Anyway, okay. The petitioner's counsel submits that as the NIT had been issued during the validity of the 2003 Act and his first running bill had been released on the basis of the 2003 Act. There was no justification for the state respondents to have released the petitioner's second and third running bill in terms of the SGST and CGST Act. Even though the second and third running bill had been submitted subsequent to 1/7/2017. Correct?
Yes,
That is the date when the
come into court, come into.
the CGST and the SGST and CGST Act came into force.
Yes.
Both on the same day. Yes. Next. The petitioner's counsel submits that subsequent to the filing of the writ petition, a similar writ petition, that is, one is enough, WPC 4201/2020 has been decided by this court by judgment and order dated 21/11/2020. Wherein it has been held where at para
56 Lordship.
has been held at para 56. That running bills which are submitted subsequent to, where is the date in the circular?
Subsequent to 1/7.
No, no. When it been held that in cases of work contracts which were partially executed on or before 30/06/2017, bills / invoices which were raised before the onset of the GST, before the onset of the CGST and SGST, TDS would have to be made as per the provisions of the
That,
2003 Act. On the other hand, if bills and invoices were raised after the
or after,
application of the, after the promulgation of the, after the coming into force of the SGST and CGST, TDS would have to be made as per the provision of the new act, of the new act, of the new act. Further, for works which were partially executed on or after 1/7/2017 and invoices were raised during the GST regime, wherein payments are received during the GST regime, TDS would be made as per the provisions of the GST Act, since the transaction was not accounted for under the 2003 Act. This court thus held that the above clarification made in terms of the circular number 3/2017 dash CGST dated 24/8/2017 was in accordance with the provisions of section 12 and 13 read with clause 6 bracket A of schedule 2 Roman 2 of the act of 2017 of the SGST and CGST. Next step. He submits that in view of the above decision of this court in WPC 4201/2020. The petitioner's case has become infructuous. However, he prays that he may be allowed to, the petitioner may be allowed to submit a representation to the authorities for.
Reimbursement of the amount.
How can I allow that?
Lordship in the next page. Last page.
Sir,
After a tick.
whatever, sir, may be allowed to submit representation to the authority. For taking the benefit of section 64A
Of the goods and
of what?
sales act.
Of the Goods and Sales Act.
It's mentioned in the-
Goods and Sales Act? Which year?
1930.
1930.
Hasn't put it.
Yeah, we have already specifically stated only 2% GST has been deducted of the remaining two bills, and earlier bills that. Because only 1% CGST and we have in paragraph 12 we have categorically stated that.
You have taken only 2% for
Only
CGST and
2%.
LGST.
He has stated that 12%. No, we have
Miss
categorically.
Udas, learned counsel for the respondents number, for all the respondents except respondents number 3 and 4.
3 and 4 months.
Yes. Submit
Paragraph 12 that.
that in view of the circular number 3/2017 dash GST so that is here mentioned in page 34, okay? Circular number. Issued by the Commissioner of Taxes Assam. Having been in view of the in view of the validity of the circular, in view validity of the circular number circular, page 37, 34, sorry. No, 36, not 30, 36. Circular number is having been upheld by this court in WPC 4201/2020. The petitioner's case has become infirm. As there was no infirmity in the TDS being made in terms of the SGST and CGST. She, however, submits that though the petitioner had made a claim that 12% CGST and SGST had been deducted from the running bill, from the second and third running bill of the petition. The state had deducted only
2%.
2%,
1% CGST, 1%
had only deducted 1% CGST and 1% SGST from the second and third running bill of the petition. Correct.
Paragraph 12 we
Yes.
have said, yeah.
Next, on hearing the cause for the party and keeping in view the judgment passed by this court in WPC 4201/2020. Oh, this court finds that the present writ petition has become infructuous. Combined as much as there was no infirmity in the application of the CGST and SGST by the state respondents while making deduction against the second and third running bill of the petition. With regard to, it is needless to add that if the petitioner is of the view that he is entitled to some concession as per law, there is no bar for the petitioner to submit a representation to that effect. The writ petition is accordingly disposed of, is accordingly dismissed as required.
Expressed. Deeply.
This is a review petition, we have sought for review of the honorable court order.
Then they're not, I don't think they want you to come, Anna. What to do?
In fact, name is reflected and we have given a copy. Yes, his name is also reflected in the copy.
Okay, right. Now we'll allow what to do,
Look,
what is to be done?
look, if Lordship allows the petition, then the petition will be revived.
Correct.
We can place the real.
So that is what we'll do. How can we keep on adjourning the matter all the time just because he's not coming?
Before Lordship has passed the order, in fact, the SLC decision was there.
Huh?
Before Lordship has passed the judgment, which we have sought for review. The another SLC was there and application is detected, but at that point of time, we could not place it.
You did not place the subsequent SLC.
Subsequent SLC not-
Is it a made up SLC?
No, no, madam. No, in fact.
But how can you, once you have approved, where is the question of reviewing it?
Kindly see on page 20. After the first SLC. First SLC meeting, it was not on in 2018. Kindly Lordship come to page 20. The first SLC was on 19/6/2018.
19/6/2018. Yes.
After that, Lord, on 7/7/2018, annexure B, page 20. The superintending engineer, Lodha NSC Circle, he has written, page 20, kindly see, to the deputy secretary, he said that I have the honor to inform you that Srimati Monica Payeng, daughter of so-and-so, has been recommended by the SLC for appointment under this office in the post of section assistant on compassionate ground. But it is observed that there is no any sanctioned post of sanctioned section assistant under Jorhat NSC Circle as per last detention received from the government by so-and-so dated 22/9/2014, copy and close. Hence, the status showing the present vacancy position of this office is being enclosed herewith along with a certified copy of the last month online pay bill of this office as a ready reference. As such, on the above circumstances, I earnestly request your honor kindly to modify the post of gather from section assistant to junior assistant against existing vacancy of this office. It may further be mentioned here that this office will have to run by only one number of senior assistant after 31/10/2018. As the present paid assistant of this office will retire on 31/10/2018, as the incumbent will attain the date of superannuation if
no any clerical staff will be appointed within this period. And accordingly, he requested as such. I request your honor kindly to consider the present recommendation of the honorable SLC in favor of Srimati Monica Payet to enable her to join in some other grade three cadre, preferably as a junior assistant. It is for favor of your kind information and positive grateful action. Then kindly come to the next page. After receipt of this letter, the under secretary, he wrote on 1/9/2018 to the SE. As regard appointment on compulsion and ground, the deputy secretary has said that I am directed to say that the chairman, state level committee, come chief secretary of the government of Assam has directed to place the matter of appointment of compulsion and ground in respect of Srimati Monica Payet at the next meeting of the FLC for reconsideration. As such, you are hereby directed not to issue any appointment letter in favor of Srimati Monica Payet till any instruction is issued from the government in this regard. So on 1/9/2018, this was the instruction given to the superintending engineer.
No, just a minute,
Lot.
just a minute.
Lot.
19/6/18,
19/6/18.
she was recommended.
She was.
Ah.
And as per recommendation, it was sent to the superintending engineer to issue the appointment order.
Correct.
The superintending engineer then observed that there is no course of action.
Let us see the first recommendation, the first approval, first SLC.
First SLC is not.
That 19/6/2018 SLC, well,
Well, it is not here, but in the project order, possibly in the.
no, I want to see how she has been recommended if there is no post.
In the requisition file, possibly it is. In the, kindly come to the honorable court order, at page 19.
Just a minute,
Page 18, kindly. The order. If I am allowed to read, para 2, the petitioner's case in brief is that petitioner applied for compassionate appointment due to death of her father on 10/5/2012. The state level committee meeting minutes dated 19/6/2018 recommended the petitioner for appointment to the post of section assistant. As no appointment order has been issued by the respondent, the petitioner has approved it. So this is an applicant question that she was recommended for the post of section assistant.
No, but there is a now, why, my question is, why was a subsequent SLC held?
Well, after the recommendation on 9/6/2018, well, when the matter was processed on 7/7/2018, the superintending engineer at page 20 that I have read.
You have got the chief secretary, you have got all the engineers there in the SLC. They have approved.
But somehow although the post was not there. But
Somehow the post, how do you somehow the post? How do section assistants are there in the entire PWD? How many?
section assistant posts are there, but not in Jorhat, NSC circle, where he was recommended. This post was not there. This is what the letter dated 7/7/2018 says, page 20. Ultimately, on the basis of this letter, kindly see on page 21. You will find the reference of this 7/7/2018 letter at page 20. And the deputy secretary has now instructed the superintending engineer that you don't issue the appointment order. And the chairman state level committee, chief secretary, has directed to place the matter for appointment.
Okay, anyway, we'll take up this matter.
Lot.
This has to be, I think that subsequent SLC will have to be challenged.
Subsequent SLC, we have annexed here. It starts at page 22.
Okay, right. Heard Mr. Dinath. Now, for the review petitioner. No one appears for the writ petition, even though Mr. R.P. Hazarika had filed wakalatnama on behalf of the writ petition. This case has been hanging for the last more than a year. don't say that. This case has not been disposed of due to the absence of the counsel for the writ petition. As more than 1.5 years have elapsed, as more than 1 year has elapsed, this court is not inclined to keep the review petition pending any longer. And the same would have to be decided on the basis of the materials on record. The petitioner, the writ petitioner had applied for compassionate appointment and had approached this court with a direction to, with a prayer to direct the state respondent, the review petitioner to consider her appointment to a section assistant post in terms of the state level committee bracket SLC bracket was meeting minute dated 19/6/20 19/6/2008. As per this court, by order dated 8/3/2021, had allowed the writ petition and directed the respondents to appoint the petitioner on the basis of the SLC meeting minutes dated 19/6/2008. The case of the review petitioner is that subsequent to the disposal of WPC 3165/2020, by order dated, no. Case of the writ petitioner is, review petitioner is that while as that the review petitioners had not brought to the notice of this court the fact that the SLC meeting minutes dated 19/6/2018 had been superseded by the SLC meeting minutes dated 7/7/2018, wherein, huh? 7/7 what? Right? When is the SLC meeting?
FLC minus it starts at
31/12/2018, 31/12/2018, wherein
page 20.
the appearance prayer for compassionate appointment. Well, no, writ petitioner's prayer for compassionate appointment had been dismissed on the ground that there was no vacant post within the 5% quota reserved for compassionate appointment. Correct?
Page 24, not within 5%. Page, that's still pending.
Next. The review petitioner's counsel submit that as the SLC meeting minutes dated 31/12/2018, which had rejected the petitioner's writ petitioner's application for compassionate appointment, had not been brought to the notice of the court at the time of disposal of the order dated 8/3/2021, passed in WPC 3165 of 2020. An erroneous order had been issued by accordingly submit that the review petition should be allowed. And the writ petition should be considered a fact by taking into account the SLC meeting minutes dated 31/12/2000. Next. On considering that the order dated 8/3/2021 passed in WPC 3165/2020 has been made only on the basis of the SLC meeting minutes dated 19/6/2018, without taking into consideration the SLC meeting minutes dated 31/12/2018. This court appears to have passed an order without taking into account the subsequent SLC meeting minutes. So, however, the state response, the review petitioner would have to take the blame for not producing. I think it was on the first day, is it? No.
Not the first day. Because the case was filed in 2020, Dr. Thompson. Affidavit of,
No, more than a year.
no, it was filed in 2020, Dr. Party order in March. We got a written instruction that Lottie was kept in the court. But affidavit of,
Maybe. You should have mentioned it, you did not mention.
no, in fact, in the written instruction, it was not.
I think you should pay some cost.
Lottie may tally cut.
Little bit,
No, but the petitioner also, we should have informed, there was the subsequent,
how do we know that? Okay, whatever I said.
31/12/18.
The meeting minute, the latter meeting minute at the time of disposal of the writ petition. However, as there could be a miscarriage of justice in view of this court not having taken into account the subsequent SLC meeting minute dated 31/12/2018, this court is of the view that the impugned order should be reviewed. Accordingly, the impugned order dated 8/3/2021 passed in WPC 3165/2020 is hereby set aside or recalled. Is hereby is here, huh? Recall. Recall. The review petition is accordingly allowed. A registry to restore WPC 3165/2020 and list the same after review. The the respondents, the state, the review petitioners should file their affidavit in opposition. Or should I say, the recalling of the order dated so is subject to the condition that you will not file otherwise your affidavit.
No, but now the instructions are there, yes, we'll file it.
Okay. Okay, don't say that. The state, the review petition should file their affidavit in opposition in WPC 3165/2020 at the earliest. I would say on the next date of here, on the next date of listing of WPC. Huh? If you file it on that day, when it's listed. Or should I fix a date for listing? Huh? Give a date. Seven November. So should file the affidavit in opposition on or before 7 November. Good.
Petition, let's say, just prior to COVID. And the COVID has taken my secretary and president today.
Okay.
And professionally, I am in the, some setback to me, I couldn't get proper. However, the incident took place in 2007, about 17 years elapsed by this time. And the management dismissed as many as 1,000 of work.
1,000 workmen.
Poor workmen, he state, more than he state, what happened?
How many workmen dismissed?
11.
11.
Inquiry, domestic inquiry was highly defective because this is a melody, it is a fully attended work. They couldn't do anything in the domestic inquiry because it is a management for person who is with inquiry and therefore dismissed. But the question is that the allegation that they have created some commotion in the garden area and assemble as many as thousands of workers. Because Bordhan is a very big state, it has not less than 1,000 workers. And out of that, 500 workers take it. And the management selected few. Domestic inquiry. Ultimately, the labor court at Jaipur they have accepted the findings of the domestic inquiry without making any charges or framing any charges against individual workers. Who did what? It is a gross injustice, for poor workers, daily workers. Hardly they could meet their daily food and other things. So that's a separate thing. That's a human consideration. But the major question is that the labor code entirely dependent upon the domestic income. He has not applied his mind, judicial mind.
Now, what is to be done?
Notice that lordship might be ask me for it also let the matter be remarked back to labor code to examine it properly.
Who is going to appear for the other side? PK Munir. The PK Munir. What to do, Mr. Counsel, when the others are not there?
Will hurt them. So it's fair enough. They may be given a chance to.
Yes, they have to be given a chance because on the last date you were given a chance.
At some point.
Right.
Yeah,
Mr. A.K. Haloy. Is it? Mr.
yeah.
They are Thakur. A. Thakur. They are counsel for the petitioner. Is present. No one appears for the respondent. In the interest of justice, leave the matter after the vacation. No one appears on behalf of the petitioner. In the interest of justice, leave the matter after the vacation.
Lordship, I seek an adjournment.
Why?
The Enkage Council, there have been some personal involvement.
Engaged council having some personal problem.
Yes.
Who is the engaged council?
KL
Where is he?
Guwahati only. He's having some problem.
District court.
No, that I do not.
Some witnesses turned up for evidence or something?
Maybe
Maybe.
the next day you positive here.
What to do? Yes. Adjournment prayer has been made. You see, I have noticed, Mr. On July, the matter was adjourned on behalf of Mr. K.L. Gupta. In June, again, on prayer for adjournment made on behalf of Mr. K.L. Gupta.
Yes. Last time maybe.
Yeah, what is your name?
TJ Hazarika.
What is to be done?
Last year. Matter may be fixed, report without.
You will not turn up. Right. Adjournment prayer has been made on behalf of Mr. K.L. Gupta. Colonel Council for the point number. It is noticed that adjournment prayer has been made on behalf of Mr. K.L. Gupta on the last two consecutive days. This is the matter. There's a stay order in your favor?
No, close back in.
Huh?
No.
There was no stay, your lordship. There was no. The order was vacated.
Yes, you are. Dated 11/5/2020. Moreover, your lordship, they have not paid the outstanding wages for 1 year.
This is the matter. After the vacation. It's okay. It is right, the appellant's counsel is present. Huh?
Madam, will pass over for the time being.
What is this matter, madam?
Award was passed in favor of our person to this award, my lord, all the workmen has been reinstated by them.
Have been reinstated.
Reinstated, they are now working. Initially, they were in
So who is writ petition is filed by whom?
by them, the government officials.
Why?
What
What do they want? They're challenging the award.
They're challenging the award, but in the meantime, all these workmen have been reinstated. Very matter.
They were engaged, they were engaged. They must have retired also some of them.
No. They are working. So let me better listed tomorrow, or
Tomorrow is Friday.
or Monday.
These are all, now next week is all motion.
Oh. Then after vacation.
Okay, please coming on there.
I don't know. Please take the time you want. Huh? Right, on the pair, as Mr. R.K.D. Chaudhary is not present. And
The concern
As-
person have been clear.
huh?
All the office may not mention it.
What?
The concerned workmen
Are
have been
working.
reinstated.
And that's paid for by Mr. A. Dasgupta, Learned Senior Counsel. This is the matter after the vacation.
Look, this is an award passed by the central government in that country. By infusing award that paid 150. The basic fact before your lordship is that so far the 2019 workers, they were initially engaged in ONGC to help the storekeepers. They were the storekeepers. Now, directly they were engaged.
Huh? Yearly,
They were directly engaged.
directly engaged.
Directly engaged. It is our period. Now, after some years, all these workmen were converted as a contract laborer. One Puniam Pukon was shown as contractor. Now, when they perform for work of 10 years, they approach before this honorable court.
Contract laborers.
Contract yes. Initially, they were engaged directly by the ONGC, but subsequently they were shown as a contract laborer.
Contract laborer.
That is, some contractor has against appointed them in the ONGC. But that is permissible, of course. From contract labor, there is an act that is called as Contract Labor Regulation and Abolition Act. Now, our prayer, after 10 years after performing this job, Milord, we approached before this honorable court for regulation of our case in the year 1995.
Wait, now, when were you engaged directly?
1985.
1985. On the basis of some advertisement?
Yes.
Was it on the basis of some advertisement? Your engagement in 1985, was there any advertisement for some post? No. How were you engaged?
That is doing for some job, direct payment system, casual type of.
So
work.
directly engaged, you said. What do you mean? So just like that, let us see your appointment order of 1985.
No, there is no such order.
Okay, so you were engaged.
But
So there's no question of directly or indirectly.
who
So
we
you are
were engaged?
engaged to help the storekeeper. Everyday basis or monthly basis or yearly basis? What?
Everyday basis.
Probably will not do.
Everyday basis. Now, what happened? After 10 years after Milord, they approved before this honorable.
No. Let's go. Then you said that you were engaged as contract laborers. Any document to show that you were engaged as contract laborers?
Their
It is their case.
case is that initially we were engaged as a contract laborer.
Okay.
Our case is that no, initially we were not engaged as a contract laborer.
I want to know your case. Why you talk about their case? I want to know your case.
My case is simple, Milord.
Yeah.
I was engaged, we were engaged as a laborer
Laborer.
Laborer.
When?
in the year 1985.
In the year 1985,
19
engaged as laborer.
laborer. And one thing I should make it clear to your lordship, that we don't have any order of appointment.
No order of
No
appointment.
order.
There
There are some certificates which were issued in our favor by the officials of the ONGC to the extent to fortify our contention that we have been working in the ONGC as a director. There are some certificates. Be that is it, my lord. The year 1995,
any engagement given to you? Any engagement cards given to you?
yes, some gate passes are there.
Gate.
All these gate passes are there.
Okay, then.
Gate passes are there. Then, my lord, we approached before this honorable in the year 1995 for our regulation. Then honorable labor court, honorable high court, this high court passed an order whereby assistant labor commissioner, ALC, Central was directed to investigate this. Whether we are really working there, whether we are directly engaged there, what was our status, what type of job we are doing, all these things are to be done by the Assistant Labor Central. Pursuant to that order, the Assistant Labor Commissioner went to the ONGC in different strokes. And all the workers were called upon, all the officials of ONGCs were called upon, they came with all records. And he recorded all this finding happening, all these things. And thereafter, he submitted this report before this honorable. Now, this honorable court, after going through this record, directed the ONGC to consider this report. And
To consider?
the report submitted by the Assistant Labor Committee. That is Exhibit A. That is a report submitted by Assistant Labor Commissioner Central
Okay, tell me, what is the WPC number?
of that case. I have annexed that order of 33366
Double 366
95
of 1995.
99. May I read it?
The order?
Hmm?
Which page is it? Is it there in the writ petition?
Yes, in this case, please. Like this, on the timing.
Okay, leaving that aside.
Huh?
So the report of the ALC came.
Yes.
Now, what is the report? What does the report say?
Page number 24.
That is what?
That
High Court.
High Court order, 24.
Civil rule.
Ah. Page 25. Having heard S.R. Bhattacharya, the learned counsel for the petitioner, and Mr. D.K. Taluka, learned counsel for the respondent ONGC, I found that out of 22 persons on whose behalf the present petition has been filed, only 3 persons come within the nature of the work as per the provisions of the prohibition of the contract labor matters. It is denied the respondent that the person whose names have been given in Annex W, the read petition are contract labor.
Which page are you reading?
Page 25.
25, yes.
25.
Okay.
336695.
Okay, yes.
He starts from page 20.
No, I got it.
Heard Mr. S.R. Bhattacharya, learned counsel for the petitioner, and Mr. T.K. Taluka, learned counsel for the respondent ONGC. I find that out of 22 persons on whose behalf the present petition has been filed, only 3 persons came within the nature, not the job, nature of work, as the provisions of the Prohibition of Contract Labor Act 1971. It is denied by the respondent that the person whose names have been annexed in Annex W to the read petition are contract labor of the ONGC. It has been emphasized by the respondent to the aid of the document filed in this read petition itself that the aforementioned persons are employees who are engaged by the contractors of ONGC for doing the particular job, which the work there was allowed to by them ONGC. However, from the report submitted by, it is important. However, from the report submitted by Assistant Labor Commissioner dated 5th January 1998, pursuant to the direction made by this court, it would appear that the person on whose behalf proposed writ petition has been filed were working in ONGC employees as employees of ONGC in the first phase. Employees of ONGC in the first phase, and then the employees of the contractor with effect from 1992 to 1990. That is the report. May you read it again, right? Just to the bottom. The report submitted by the Assistant Labor Commissioner dated 5th January 1998, pursuant to the direction made by this court, it would appear that the person on whose behalf the proposed writ petition has been filed were working in ONGC as employees of ONGC in the first phase. And then the employees of contractor with effect from 1992 to 1996 in various capacities. Person appearing in serial number 10, 11, and 12, 11 and 18 of Annexure 1. The state report appears to be engaged as a typist, whereas the others were engaged coolies and manual labor. It is not possible for this court, at this stage to make an order for regulation of the concerned workmen as the regular employees of ONGC. Better course would be that the ONGC may approve, ONGC may be approved by the petitioner to let it be examined the matter in the context of the correct factual position that may be obtained in its own report. ONGC being public undertaking is supposed to do the things in keeping of the provisions of the Act referred above, as desired by the learned counsel for the petition. I therefore leave the matter for better discussion of the ONGC authorities to pass appropriate order in this respect after examining as to which the person given benefit is conferred the status of an employee of the organization wing. Requisite inquiry in this regard may be made. Necessary order may be passed in a period of 3 months from the date of filing of the application in this respect. The petitioner or by individual employee. In case the petitioner or the employees concerned still agreed, they may approach the labor court for appropriate relief in accordance with the law, with these observations, these requisitions of the court. Now, this report submitted by the Assistant Labor Commissioner, that report was not considered by the way. Now, Miller, we have no other option. We approached before the Assistant Labor Commissioner for making a reference before the investor. Thereafter, this reference was made before the industrial. Now, I'm just giving a brief aspect. Initially, 22 workers were there. An award was passed in favor of the workers. In favor of only 3 workers. They were working as typist, office assistant, and in favor of 3 workers. And so far the other workers are concerned, it was of the opinion of the learned presiding officer. They could not establish their case by adducing proper evidence to the effect that they served for a period of more than 240 days or something like that. Now, both the parties were unhappy by this hour. Management also prepared a writ application, and we also prepared a writ application. Our case before this honorable court is that our evidence was not at all considered. 2 workmen's evidence was not at all considered. Not at all considered. Based on that submission, the Honorable Guwahati High Court referred, remanded back the award to the industrial signal for trade activity. So they are awarded. the award. So thereafter, matter was adjudicated. And both the parties were allowed to adduce the evidence. We adduced some evidence, they had not adduced any evidence. Now, in that case, what was our contention? Our contention was that the Assistant Labor Commissioner has already conducted an inquiry. That is Exhibit F. And yeah, in terms of this
Exhibit F or H?
F. That exhibit is which need, there is also in the report. Exhibit F. Our contention is that the matter was examined by the Assistant Labor Commissioner in presence of the ONGC official and the work. And as per that report, it was of the view, the Assistant Labor Commissioner was of the view that the work performed by us is of perennial nature. And initially we were directly employed by the ONGC, and subsequently we were shown as a contract labor. That is one aspect of this. And to fortify our contention, some officials under whom we were working, they have issued some certificates in our favor. We have exhibited those certificates. Our point is that the central government, that is the government of India, in exercise of their power conferred under Section 10 of the Contract Labor Regulation and Abolition Act, prohibited the engagement of contractors in a storekeeping job of points. That is Exhibit W, that mechanism report. Prohibited this job. So
How many points is there?
Huh?
Yeah, this is the fourth point, yes, sir.
one from the Exhibit F. Exhibit F is the inquiry made by the assistant.
No, you are challenging the award. You see what has happened was,
3 or 4 points.
Huh?
3 or 4 points, my challenge.
correct, yeah, correct. So those 4 points, what are those 4 points from the beginning once more?
On Exhibit F,
Ah,
that is the report submitted by the Assistant Labor Commissioner Section.
yes. So
Second.
that is in your support
That is in my sub.
with regard to all the writ petitioners.
Yes.
Okay, then,
With regard to all the petitioners, job of the expedition. It is a notification issued by the government of India with respect to hundreds of establishments. And one of such establishment is ONGC. And in this ONGC, my lord, may I pass it to your lordship? Absolutely.
oh, you have made a challenge to the award. You see, no, you were saying that the award was passed by the labor court, by the tribunal. Now the tribunal award was challenged here by both the parties. And then this court had sent it back to the tribunal. Now, what was the decision of the tribunal?
Decision of the tribunal is that we were contract laborer.
You're a contract laborer.
The contract laborer, and we are not entitled to be considered as the employees of the ONGC. That is the decision.
Okay, so you are contract. Now you are challenging that. Firstly, on the ground of Exhibit F.
F.
Secondly, on the ground that
That the engagement of the contract laborer was prohibited by the government.
of contract laborer was prohibited. Under what law or under what?
Under Section 10 of the Contract Labor Regulation and Abolition Act.
Number three,
And this notification was issued on 8/1/1994.
what notification?
Abolition of contract labor.
No, you have already said that engagement of contract labor was prohibited. So that is the second point. What
And
is, what,
for that prohibition, a notification was issued.
okay, notification issue.
And that notification is Exhibit W. Dated 8/1/1994.
Exhibit W.
8/1/1994. So my question,
The notification is of 8/1/94. That,
now, Millard, my case is simple because
these are only 3 points. What is the fourth point?
fourth point is that when there is a notification prohibiting the contract labor engagement, despite that notification where the contract labor is going on, the arrangement of the contract labor, it will be considered as a paper arrangement. Paper. On. Now, Supreme Court, just give me, Supreme Court, in a number of cases, held that when the contractor is not a genuine contractor, he is shown as a contractor through a paper arrangement, then this contractor should not be considered as the contractor of the principal.
Who is shown as a contractor?
Hmm?
You said, you see, first thing is exhibit F, then secondly you said engagement of contract laborer was prohibited by government under section 10. Then you said because of how a notification was issued in respect of this, Contract Labor and Abolition Act. And now, in view of this Abolition Act, the engagement of the contract labor was to be considered as a paper rate.
Paper.
Then, where is the question of contractor coming? Who is the contractor here?
The contractor's name is Tunuram Pukan. He is MW2
He is the contract laborer.
contractor.
He's the contractor means
He
he
is
is the contractor who provides the labor.
Here,
Tunuram
Pukan. MW2.
Yeah.
Now, Supreme Court in a number of cases feel that when the contractor has nothing to do, or the contractor is something like a paper arrangement, then the employee concerned who are working on the contract labor act should be considered as the employee of the principal. Simply, say Bongaigaon Refinery, ONGC, they are the principal employer. They want to do something. So without employing anybody directly, they engage a contractor. And contractor is allowed to engage some laborer to perform the jobs of ONGC. Then the laborer who will be engaged to perform the jobs of ONGC, they will be called as the contract labor. And the contractor who will engage them, they will be considered as a contractor.
Correct.
And there is an act. That act is called as Contract Labor Regulation and Abolition Act 1970. And according to that act, the contractor has to be a registered contractor.
Correct.
And the principal employer establishment to be a registered employment. All these things are to be formalities are to be.
Then so
So Now, look, if the contractor is not permitted to engage a contract labor in a particular,
If he's not registered.
he is not a registered, and that apart, there is of course one factor, not the sole factor. That apart, your lordship meant section 10. Section 10 of the contract labor regulation and abolition. Under what circumstances the contract labor can be given?
No, out here is the contract laborer, is the contractor, a registered contractor or not?
Initially, he was not at all registered contractor.
But subsequently, he was registered.
Subsequently, it is his case that initially he was not a registered contractor, and subsequently in the year 89, he was
89.
89.
And then these laborers were taken in only 92.
Laborers were taken in the year 1985.
85.
80, not 90. And he could not produce the document. He has stated here, my license, I got my license in the year 1980. And he could not produce the document that he paid the worker wages from 85 to 1992. According to him, the papers which he maintained in office was destroyed due to flood. So he only produced the document 89 onwards. Now let us go to the provision section 10. Notwithstanding anything contained in this act, the appropriate government, after consultation with the central government, or as the case may be, a state board prohibit by notification in the official gazette employment of contract labor in any process, operation, or other work in any effort. So that is the power of the central government. So while doing so, what factors have to be considered that has been stated in subsection 2. Before issuing any notification under subsection 1 in relation to an establishment, the appropriate government shall have regard to the condition of the work and benefits provided for the contract labor in the establishment and other relevant factors, such as, these are factors, whether the process, operation, and other work is incidental to or necessary for the inquiry, industry, trade, business, manufacture, or whether it is of perennial nature, clause B, perennial nature, that is to say, it is of sufficient duration, having regard to the nature of industry, trade, business, manufacture, or occupation that is carried in the establishment, and whether it is done ordinarily through a regular worker in that establishment or an establishment of similar director, whether it is sufficient to employ considerable number of full-time workers. If any question arises, whether any person or operation or other work of perennial nature, the decision of the appropriate government thereof shall be final. Now, look, who for this?
Yes.
Now, some other things may kindly be looked at. Section 7 has some bearing. registration of certain establishment. So if any establishment, employer of any establishment wants to engage contract labor, so they should be registered under this Contract Labor Regulation and Rule Act. Every principal employer of an establishment to which this act applies shall, within such period as the appropriate government may, by notification in the official gazette, fix in this behalf, with respect to the establishment generally or with respect to any class of them, make an application or to the registering officer in the prescribed manner for registration of this establishment, provided that the registering officer may entertain any such application for registration after expiry of the period fixed in this behalf, if the registering officer satisfied that the applicant was prevented by sufficient cause from making such application in time. That is the duty of the principal employer. Now, the section is revocation, etc., let us effect of non-registration. That is not very, now 10. Now, your lordship come to section 12. That is, the contractor should have a license. I have referred section 10, section 8, now section 12. Just some relevant for licensing of contractor. Contractor should have a license, which effect from such date as the appropriate government may, by notification in the official gazette, appoint no contractor to whom this act applies shall undertake, execute any work to contract labor, except under and in accordance with the license issued in that behalf by the licensing officer, subject to the provisions of this office act. A license under subsection 1 may contain such conditions, including in particular conditions of work, hours of work, fixation of wages, other essential amenities in respect of the contract labor, as the appropriate government may deem fit to impose in accordance with the rules. It may be under section 35 and shall be issued the payment of such fees on the deposit of such subsidies, some, if any, as security for due management of the condition as provided. So for both the principal employer as well as the contractors are required to be registered under this provision. But so for the principal employer is concerned, when they are registered. But so for the contractor, that is MW2, Uniram Pukon, who appeared before the Judicial Tribunal, he has stated that I obtained the license in the year 1989, but I was acting as a contractor since 1980. That is it. And his contention is that I am directly paying the contractor, not the wages.
Directly
Paying wages to the contract level since 1985. That is his contention. Then when we ask, you produce documents, we don't know. So far the documents of 1985 to 1989 is concerned. That is not with me. All these documents were destroyed by flood, damaged by flood, so I am not in a position to produce these documents. That was his content. Now, where the engagement of contract labor is concerned, that was abolished in storekeeping job. Because the storekeeping job is a perennial job.
How long are you going to take? No, I'm not in a hurry. I just want to know because I can pace myself. Well, how long will you take to finish your article?
Not more than half an hour. Half an hour to 45 minutes, at best. 45. So for the Supreme Court judgment is concerned, I will just refer, take the paragraph. Or your lordship may take it a day after tomorrow.
No,
Your
no, no,
lordship
no,
may,
no,
in the
no, no.
meantime, your lordship may go through the paper.
Huh?
That will be better.
No.
May have a glance on the, let me finish within 10 minutes, and your lordship may take it up. Just, and tomorrow or day after tomorrow. Then it will,
Tomorrow to no chance.
day after tomorrow.
And day after tomorrow is Saturday.
Oh, sorry, Monday. I just want to give some current picture for nothing. I will not trouble you lordship by going to talk.
So basically what you're trying to say is that since you started work from 1985 and as the contractor got his registration only 1989, the workmen were working for the ONGC directly
From
since 1985. And the subsequent coming into the picture of this contractor does not change the fact that the workmen were always in the service of the ONGC and not this person. Is it? Is it?
And these contention, what I am stating, and what appears from the cross-examination of the contractor MW2, these contention will be 145 by Exhibit A.
145?
Sorry, will be 45,
45.
45, substantiated or corroborated by Exhibit F. That is the inquiry made by the assistant labor.
But was the assistant labor commissioner, was he examined? Was his evidence taken?
No, his evidence was not taken.
Then
His evidence-
how can you say the contents of the report made by him are correct?
yes,
when-
that was the finding of the industrial tribunal, of course.
Actually, it has to be examined.
Now,
Content,
yes.
even the document would have to be exhibited by that person.
Hmm.
And not only the document, the contents of that document would have to be clarified by him.
yes, that was the whole thinking of the planet presiding officer also. And for that reason, as you also is thinking, that was the thinking, and that is creating trouble to me. Because your lordship is thinking something and same thing is talked about by the presiding. Now, Millard, one thing, that inquiry was conducted pursuant to the order passed by the Samar.
Maybe. You see, whatever it is, maybe. You see, because the issue of facts was not there. I don't think that report made by that person,
Assistant Labor Commissioner.
even if it had been submitted by way of an affidavit, I don't know if it was submitted by way of an affidavit before this. Assuming it was submitted by way of an affidavit. Now to make that into substantive evidence, the persons who are affected by it should have a chance to cross-examine that person as to the correctness of what has been stated by him in that report.
Well, this is a document. This document may be considered as a public document.
Is it a public document? I doubt. What is a public document? This is a dispute on, this is a question on facts.
Okay.
Which even the court, if it was a public document, then the High Court would have not sent the matter back. It would have decided the matter on the basis of that document, but the High Court did not.
I will make my content.
Huh?
I will try to satisfy your lordship. But if I fail to satisfy your lordship, then also I have a case. Other. Not that it is my whole point.
Okay.
If your lordship agrees with me, then it will be very easy for you. But And if your lordship does not agree with me, then I have to.
No, no, if I agree with you, then they will have nothing to say.
Yes, yes, that is of course.
I have
They
to,
should be allowed to say something.
yeah,
They should be allowed to say. No,
I am just voicing my concern
oh, yes, sir.
and,
What your
and
lordship thought, that was the feeling of the society. Yeah, as the assistant labor commissioner was not called upon the witness box, the ONGC sanitary notification deprived of cross-examination. So as they were deprived of the cross-examination, so these witness cannot be. That is one.
otherwise you could have examined those persons that this assistant labor commissioner had examined. You could have called them as witness.
That was our mistake probably. Or other was thinking, we were under impression that this is a public document. And I shall try to satisfy your lordship.
What do you,
Whether
please teach me the law on public
Yes.
documents. What is a public document?
So for contract labor regulation and policy concerned. Now, Assistant Deputy Labor Commissioner rule. Now, he's a member of the board. Section. three. Section 4 of the contract labor regulation. Only.
Yes.
The state government may constitute a board to be called a state advisory board. The state advisory for contract labor board, hereinafter referred to the board, to advise the state government and such matters arising out of the administration of this act, as may be referred to any to carry out the other functions assigned to it under this act. State board shall consist of chairman to be appointed by the state government. The labor commissioner is ex officio or in his absence, any other officer nominated by
No,
the.
no, why are you reading this? What is the relevance of this provision?
He is a statutory person.
Huh?
He is a statutory person.
Who is the statutory person?
Labor commissioner or any other.
He is a part of the state advisory. So,
So
how does it have, how does it have, what is the relevance of this? He's a statutory person, whatever. But he's a part of the board. He cannot stand by himself. So what do you want to say? What do you want to say? I do not know what you want to impress upon this court by reading section 4.
well, section 74 of the Evidence Act. That's some.
Okay, that's great.
I will basically correct that.
Okay, give me evidence there. Okay, that way.
That
No, but then this is, you see, section 4 speaks of a state advisory board.
now again, another thing is that your lordship taken some rule 29 of the contract labor regulation and regulation act.
No, it is, 77 people.
Public.
Okay, where is the impugned order?
Here.
Let us see the impugned order. Page.
No, another aspect, just before that's before coming. to this.
Yes, yes.
For the, let me for the timing.
Yes, yes, yes.
For the, let me for the timing, let me keep it up. Now, yeah, second. Now, it is evident from the material on report that all these workers are working in water,
Okay.
storekeeping. It is the evidence of the management also. And it is the evidence of the workmen also.
They're working as helpers to the go down storekeepers.
So
They're not the storekeepers.
they are not.
They're the helpers to the
performing the
storekeepers.
storekeeping job.
In the very beginning, you said that they were helpers, engaged as helpers to the store.
Yes, storekeeping job was prohibited.
Okay.
Storekeeping job was prohibited, and contractor were engaged as a storekeeper, and he used to engage the contract laborer. Am I correct now? Yes. That storekeeper is prohibited.
Storekeeping is prohibited.
Storekeeping is prohibited. And the
Where does it say storekeeping is prohibited?
that notification.
Where is that?
Notification. Thank you.
I think we're going to take a long time.
Yesterday when I got it now.
Now you cannot find it today.
Yeah, that is the problem. Now I have marked it. And I just, oh yes, yes. I got it.
Page?
Yes. Sorry.
No problem, no problem.
I'm sorry.
Oh, it's not here. It's
No,
not.
it's the record, in the case record is there.
Okay.
So I got it.
I turned the page. I don't know where it is. So thick.
I can pass it to them. That is item, actually, it should have been item 70. I don't know why I have written item 20. By mistake, I should have. It should be item 70. Well, and storekeepers. Just a wait for your. Just or record item number 17 of the notification and just.
Item
Item
17.
number 70, I wrote it item number 20, should have been item number 70 of notification dated 8/1/1994, exhibit W. Exhibit W and serial number Roman 8. Serial number Roman 8. That is captioned as I'm just storekeepers. You understand writing. So this contractor should not be, a contractor cannot be a store.
Even a contract laborer cannot be a storekeeper.
Yes. And if he is not a storekeeper, he cannot engage any contract labor for doing it.
You mean a contractor cannot be a storekeeper?
And if so for the employees engaged by him, he cannot engage any contract labor at all.
Let me see the notification. Is it true? Look, he's saying that this notification 8194 prohibits a contractor from being a storekeeper. Storekeeper, what is it?
Item number 7.
Yes.
When
No, where does it say that prohibition? Where is the prohibition?
at the very beginning,
Workshop prohibited.
Okay.
Storekeeper.
so define prohibition will just put a number of establishments, FCI and other establishments.
So you see, but then you said that they were helpers to storekeepers. They were not storekeepers.
They were not storekeeper, but storekeeper cannot be a contractor.
That is all right. But then
If the storekeeper,
no, the thing is this. Agreed, storekeepers cannot be contractors.
Yes.
But then the issue is whether the writ petitioners were storekeepers or helpers to storekeepers.
helper to the store,
Then helper
helper to the,
is helper to the storekeeper prohibited?
if the contractor is prohibited, then the contractor cannot engage in contract labor.
Contractor is prohibited only for being a storekeeper.
Oh.
There's a difference between a storekeeper and there's a difference between a helper to a
Storekeeper.
Okay,
Yes.
so if whether there was any prohibition for a contract laborer to be a helper to a storekeeper.
No, look, contractor cannot be a storekeeper, it is clear.
That is all right,
I-
but I'm talking about helper.
Okay. Now, if the contractor engages some persons for helping him,
Nah,
for helping him.
for helping the storekeeper.
Lifting,
Uh-huh.
lifting, stacking,
Whatever.
lifting, stealing, stacking,
Cleaning, whatever.
cleaning, all these things are there.
Uh.
So that he cannot engage.
He comes under,
He cannot engage this person
why?
because he contractor himself cannot be a contractor, a storekeeper.
Okay, that is your stand. Okay, you done. Okay, then,
Contractor cannot engage. And the job performed by those contract laborers were lifting, stacking, etc.
okay, so that means the storekeeper has to do everything by himself.
No,
Then,
storekeeper has to do to his subordinate.
so his subordinate,
Ah.
his subordinates, can they be called, can they be called helper? Can they be called general? Or what name should we give the subordinate? What,
Or
Chotu
the
or what?
Khalashi, they are called as Khalashi,
So we can call them helper also.
helper also. So when the contractor cannot be a storekeeper, so he cannot engage any other person for his helping. Because he is not allowed to enter in this place to do the job of storekeeper. Then he is prohibited.
Okay, he's not allowed to be a storekeeper. Okay. But the question is this. Is there any bar for a storekeeper to have a helper?
No,
No bar.
no. On the contrary, my lord, if your lordship found to section 2C, That will be clarified. Section 2C of the contract labor regulation and regulation act. Who is contractor? And who is contract labor? Contract labor. Mary. Contract,
After lunch, we are giving the floor to Mr. Yes, After lunch at 2 o'clock, we'll be giving the floor to him. You have to finish everything by 1. You said 10 minutes, already you've taken.
no, 45 minutes. Initially, I thought half an hour, then actually it's 45.
You've already taken, we started at 12 o'clock, I think.
No, no, no. But
No.
yes, yes. But yes, yes, 12 that. 12. But
Just
yeah,
then.
of course, I think you. I think it was 12. But anyway, let me consider 12:10.
Okay.
Or after, yes, you can argue, no problem. Then I can reply.
Correct.
That's all right. You can argue. Now, what is who has contract? Contractor in relation to establishment means a person who undertakes to produce a given result. Given result for the establishment, other than mere supply of goods or articles or manufacture or such establishment who contract labor. So he must undertake to give some result. Who contract labor?
Yeah.
So here he has engaged some laborer for the purpose of total lifting, shifting. So my conclusion to your lordship is that his job he cannot perform in view of the notification.
Who cannot perform? Who cannot perform?
Contract.
He cannot perform the contractor cannot perform the work of a storekeeper.
By engaging some contract.
Okay.
So as he has done so the arrangement which was made by the ONGC and the principal there is a paper act. And for the time being, Lord, let me give some judgment, Lord. Because we have, as soon as my friend will argue. No, no problem. One is 78, AIR 1978.
How many judgments are you giving me?
I have a lot of judgment. I will just
No, that's why I'm asking you, how many are you giving me?
three. I will
Not more.
I get all that. I will. No problem.
Yeah.
AIR 1978 is a Krishna judgment.
Yeah, 1978.
4 STC,
For STC.
page 257, para 5.
Yeah, 1978.
Sorry.
SC, you mean?
Uh,
Cannot be SCC.
No. AIR 1970, page 1410.
Yeah, 1978.
SC,
SC.
1410.
1410. Yes.
Equivalent to 1970.
No. Okay. Equivalent to, okay. Equivalent to
78 4 STC 257.
$1978 for SSC 257.
Paragraph 5. Ready? The true test may with the PPT, we indicated once again where a worker or a group of workers, laborers to produce goods or services, and these goods or services are of the business of another, that other is in fact the employer. He has economic control over the worker, subsistence, ill, and continued employment. If he, for any reason, took off, the worker is virtually laid off. The presence of intermediate contractors with whom alone he, sorry. Sorry.
It's okay, carry on. I'm hearing you.
Paragraph 5.
Good. Yes. 1 o'clock. We'll have to take it up after lunch. I've got a meeting at 1:15.
All that, no problem. And another judgment I can just, your lordship,
Yes,
just, I will not
another
read it out.
Yes, yes.
That is, it is constitutional bench judgment, 2001, 7 SPC, page 1,
2001,
7 SPC, page 1,
page 1,
para 107,
107,
1999, 3 SPC, 601, para 9,
1999,
9 SPC,
3STC.
601, para 9.
Okay.
So, how would you consider at 2 or day after tomorrow?
Oh, no, we can, after tomorrow, I'm not coming.
Sorry, I will be there on Monday. Or you can consider, anyway, I am free to do today.
No, we'll take it up. It depends. I am free also. At 2, we'll take it up.
Then I shall become ready. Yeah, I have not read out the relevant portion of the impugn award. That is, that I am just giving the brief.
Brief.
Mr. Miller, my nearly interesting another thing. 1995, 5 SCC. It is good to hard work.
1995,
5 SCC,
5 SCC,
page 27.
27, para,
Para 53, relevant page 63.
para 53 and 63.
Para 53, page 60.
Oh, para 53 page. Okay.
Okay.
No, I already here. I've got one.
Like, I prefer 3, but he is in 62.
Your 10 minutes have been converted into 30, 45 minutes, 30 minutes. And citations 3 into 4, right? No problem.
My lord, I beg to mention the next item on behalf of the overlord. He met with some difficulty. He has the brief also. My lord, may kindly respond.
Motion the last week. Hearing. Is buttered or something? No. So they've got to give you back the vehicle. After lunch, 2 o'clock, you got free. It'll take 5 minutes.
It's unwilling.
Oh, is that it? Right. On the paper, adjournment made on behalf of Mr. P. Gogol. P. Gogol, who is allegedly unwell. Who is unwell. This is the matter on
Any day.
Monday. Okay, we'll try Monday. Okay, just try one thing. Just try one thing. It's the PJ cycle, the balance PJ causes happen. That the basis for seizing the vehicle, truck of the petition. I think this is a vehicle of the petitioner. Has been withdrawn. Has been withdrawn.
I've written it. The restriction of Article 226.
Huh?
Restriction of the Article 226 in the industrial terms of the awards, my lord, is very limited. In this aspect, my lord, I can, if I want to discuss, my lord, sure. So, moreover, my lord, here what happened, my lord? My learned secretary, award. Just page 114. The 11th portion, my lord, your lordship may come. That's page 124. I'll be the part from the. After remand, madam. After remand.
Okay,
After the remand, the matter was.
page
120.
124, which line?
From beginning, madam, paragraph 12.
Paragraph 12 is 123.
123. Oh, in my, madam, it's 124. Anyway. Okay, let's see.
Yes.
After the remand, the matter of the workman side examined 6 more witnesses. So, Oxini Bottle reported that he was directly engaged by ONC in the central store in the month of January 85 and continued to work for 2010. He further stated that gate passes were issued to him by Central Industrial Security Force, which indicates that he was continuously in service from so. He executed first gate pass execution. Further reported that he continued service from January 85 to 1956. And from January 87 to 1994 was established by executive, which is a report submitted by SPLO. He also spoke several gate passes issued in favor of another worker named Dr. Daswar. He however reported though he and others were engaged under the direct payment system of ONC, subsequently they were shown as contract laborers under contractor to Niram. He also reported while discharging their duties, they were under complete and direct control of ONC. He also executed certain certificates to exhibit X1 showing the concerned official so issued a certificate showing him a regular continuous. During cross-examination, it appears that at the time of deposition, he was 61 years old. Admittedly, he did not submit appointment letter issued to him by ONC, engaging him as a casualty. He also admitted that no salary slips were ever issued to them at that given time. He further admitted that get pass exhibit so pass holders were stated to be contract labor and it was not non-employee pass. But within the get pass also, contract labor and non-employee pass. He further stated that during cross-examination later on, that he came to know they had been shown to work under the contractor Punjab. Activity access certificate issued by an ONC officer of ONC that he is a regular contingent worker in 85-9. Evidence of the workman is 6. Nilavan Datta was more or less similar in the same line of MW5. During cross-examination, he stated that he left ONC in the year 1995 because ONC did not keep him his service thereafter. He also admitted that when wages were given, no salary slip was given to him then. He ever denied that they ever worked under contractor Namla. W27. Onion Bora also stated that he worked directly under ONC from 83 to 95 at Kalasi, and he was never appointed by contractor. He also issued get pass. He also issued a certificate with Y by an officer of ONC stating that he was an employee of ONC. During cross-examination, he admitted that he did not submit any appointment letter. He also admitted that exhibit Y is a get pass, wherein genuine signature of contractor Tumiran Pukon is there. And exhibit Y, it was written that he was a contract labor. WW8 Bhavani Gogoi also claimed that
to have worked directly under ONGC from 1986 to 1985 and get pass was proved. He also proved a certificate issued by an officer of ONGC as Exhibit YF, showing him an employee of ONGC. During cross-examination, he himself admitted that no appointment letter was ever issued to him, and that to enter in ONGC premises, everybody requires a pass to be issued by CIF. My lord, whoever goes, my lord, even a visitor goes, my lord, he has to obtain a pass. He also proved Exhibit YF certificate wherein it was mentioned that he has been working since 1980. He also admitted that no salary slip was issued to him. He further admitted that ONGC made any appointment, the employees are given salary slip showing disbursement of salary by ONGC. MW9 Abdul Rahman also reported that he worked under ONGC Khalasi up to 1995 without any break, which can be proved by the get pass issued by CIF. He also stated that they were engaged under direct payment system and subsequently they were shown as contract labor under a contract of tourism coupon, which according to him was nothing but a payment arrangement. During question, he admitted that he knew that when ONGC made any appointment, the employee are issued salary slip and no such slip was ever given to him. MW10 Ranjan Bora also claimed that he was directly engaged by ONGC in 85 to 95 and get passes received to him by CIF. He also stated that he and others were engaged by under direct payment system, but subsequently they were shown as contract labor under a contract for tourism coupon, which is nothing but a paper annual. He also proved the certificate Exhibit YM issued by an officer ONGC mentioning that he was a regular constant worker. During prosecution, he stated that Exhibit YJ is a contract labor has been mentioned. And after 1992, there was a break and he joined in 1984. He admitted that he was a worker under contract for tourism coupon, which he came to know later on. The list of evidence of the management side was as under. He examined three witnesses, MW1 Ranjit Porgohai, a manager of the rank, stated that the contract workers were engaged by the contractor to execute certain works, namely lifting, shifting, cleaning, stocking, distribution of materials in Godon, opening of boxes for his work. He proved the contract tender Exhibit 1A as job description. He also executed the work orders as Exhibit 2, 3, wherein the jobs mentioned were the same in the tender. He also proved the bill submitted by the contractor to ONGC in respect of the executive work mentioned the work. He also exhibited a letter issued by the contractor stating that after expiry of the contract on 31/3/96, he had not engaged any contract labor since 1/4/96. He also exhibited a license issued to the contractor RP coupon by the company authority in the so and so 29/9/18. The contractor to Mira coupon was examined by the management as MW2. He stated that the concerned workers were engaged under him from 87 to 95. He proved the payment register Exhibit 12. He also stated the loading, shifting, box opening, stocking with the kinds of jobs that were done by the concerned workers. He further stated that he used to pay their wages. In this connection, we look to Exhibit 18. It appeared that names of the workers as well as their wages and the signature of the contractor were there. It was countersigned by the official as per requirement. All of the signed by the official. The management side examined FW3 tried up to collect mainly to show that only a handful senior officers in the ONGC are authorized to issue certificate, and if the certificate is issued by an officer who is not authorized, action may be taken against him. It may be because the case that several workmen witnesses exhibit certificates issued by ONGC stating that they were working in certain capacity directly by MW3 proved that Exhibit 15 along with the enclosure showing that such certificate cannot be issued by anyone other than those mentioned there. He also stated that such unauthorized issuance of certificate would affect action against hiring officer. Exhibit 16 also indicated that the process of action was being initiated against officers who issued such certificate unauthorized. The concerned workers claimed that they were initially appointed directly by ONGC, but subsequently they were shown to have been engaged to a contractor, which was nothing but a mere paper annual. But there was no evidence to show as to how they were directly appointed by ONGC. Admittedly, no appointment letter was produced. Mere issuance of a certificate by officer establishment would not make the workers direct casual labor workers. Another issue raised by the workers was that the contractor did not have a proper license when they were shown to have been engaged by a contractor. Yet, another issue was raised in the report of the same Lieutenant Commissioner, which claimed that they were being engaged by ONGC for a long period, and most of the works done by them were banned in return. post could have been executed through contract level. No. Another issue was continuation of the management after notification by the government in the year 1994 prohibiting engagement of the contract laborers in oil certain work. They also formed certain get passes to show their employment. The claim of the concerned workers was in the view of the fact that entitled to be reinstated and regularized in service with consequence of any. In this matter, the management side raised the fundamental issue of non-existence of the employer-employee relationship among them and the concerned worker. According to them, the concerned workers were contract laborers engaged for contractors, and the management was nothing but principal employer. Further, a contention of the management was that it is for some initial period contractors did not have the license, but this per se could not render the contract invalid. He also contended the issuance of notification under so for provision of contract labor in the year 1994 did not cover the work done by the concerned worker. Lastly, it was emphasized that the concerned LC who submitted a report narrating the nature of work of the concerned workers had not been brought as
No, no, one thing. This para 18.
Yes.
Further contention of the management was that though for some initial period, the contractor did not have the license.
Yes.
This per se would not render the contract invalid. That means the court has come to a finding that the contractor, though did not have a license initially, he was engaging persons for the ONGC. Is it? So that means that, so now that the petitioner is saying, because of that, now the petitioner becomes, the ONGC becomes the contractor, becomes the establishment which can contract.
No, I have the judgment of the Supreme Court, Nala, that only penalty can be.
But the only penalty can be.
I'm telling you. Which is that? On the title. I gave you. Okay. Okay. Other than. Yes. Only this panel, section 23, 25, my lord. Vitara, he does it, my lord. It will be penalized. The contractor will be penalized.
Where does it say that?
My lord, yes, that's it, yeah, my lord. Paragraph 19 to 22.
19.
19 to 20. So 22 may be seen, my lord. But for the High Court to inquire into the question that whether the employment of contract labor is this person in court because the method of the government considering a method required of the process that will fail effect. The only consequences provided is the act that the employer or the labor contractor violates the provision of section 9, section 12, respective is a penal provision as indicated under the act whose reference will be made in section 23 and 25. We have a firm view that the proceeding under 220 of the Constitution may be contractor or employee has violated any provision of the act or the rules. The court could not issue any mandamus giving the contract labor as has become the employees of the principal. Who would like to protest any violation of the decision of the contract, High Court or future High Court. Since these decisions are under challenge in court, but would place on record that do not agree with the affirmation of observation of Madras High Court about the effect of non-registration of the principal employer for non-licensing of the labor contractor, nor in the view of the Bombay High Court as quoted. We have viewed the decisions of the Kerala High Court and the Delhi High Court are correct and we have to proceed. Now, my lord, paragraph 19. To establish employer-employee relations among others, the following need to be established by the party claiming such relations. I accept that. Who appoints the worker? Who pays the wages? Who authorities to pay? Who can take action? Extent of control of supervision and whether there is conflict of interest. Coming to the composition of payment of wages, we establish that wages will be paid by the contractor in presence to the officer or the principal employer, as was required. There is absolutely nothing in the report to even suggest that the concerned workers receive their wages directly from principal employer. It was established through evidence that it was the contractor who used to pay the wages of the concerned workers according to the number of workers paid. Exhibit 2 and Exhibit 18 are relevant summary. The get passes sold by the workers technically were issued to facilitate their entry in the field of the ministry, which was a protected area. Right? But in these passes, as discussed earlier, if you was sea labor and non-employee pass to remain. These are not even iota of evidence to show that concerned workers were appointed by NCI. It was therefore clear that ONC did not appoint the concerned workers directly and their wages, etc., were directly paid for contractor. In this regard, in regard to control for concerned workers, it would be natural that the institution where the workers will be engaged by the contractor would have basic control because ultimately it was the institution's work which is being executed for the contractor. Rest test is one of the total control, including power of removal, initiation of distributors. There is absolutely nothing to show that management of the NC had control over the concerned worker. It was contractor who used to pay the wages and it was he who had ultimate control. The claim of the workers that contract was a mere paper arrangement also did not appear to be fully accepted. The concerned contractor who was examined as April 2 proved that he used to engage them and used to pay their wages. He also proved the contract agreement with only regarding existence of certain work for which he engaged the contract worker. It further stated that once the contract finally expired, he disengaged the contract worker admittedly at the time of first agreement. He did not have a valid license, though he acquired license soon after. But non-available license sector cannot purchase the standard contract. Reliance on the workers of the service certificate discussed earlier, issued by some officials to claim their direct engagement in ONC appear to be misplaced in as much as those officials are not authorized to start. Evidence of immunity would show that actions are being taken against such officers. That apart, if the employment of a person in an establishment is held to be proved only by issuance of a certificate by any officer of the establishment, it would lead to a chaotic situation. To prove any employment, permanent or casual, there is to some kind of appointment or engagement letter and at least some document to show that concerned establishment was directly paying the wages to the owner. Admittedly, none could produce any such document. On the contrary, the documents proved by the management side, as discussed earlier, would categorically indicate the concerned workers were engaged for contract. Coming to the notice issued by the government of India under Section 10, certain categories of job as typist, storekeeping, of etc. were prohibited to be executed for contract. But the nature of the work mentioned in the tender did not seem to be of such nature as job mentioned in the notice. Another aspect argued by the Learned Senior Council was that substantial work ONC exploration of rigs where certain rigs are abandoned. The contract for engagement workers should come to an end. He submitted that from rigs of the relevant localities has long been abandoned. He also submitted the establishment of rolling burden of staff for which voluntary retirement was also important. He referred to it. In view of the discussion, we appear to me that concerned workers failed to prove their employer-employee relationship in ONC and the beginning of time. The concerned workers, they are my lord, now I shall place the my lord.
What happened in 1995? They were terminated or what? These workers?
95, my lord, the contract was not renewed because the contractor was given some job. Contract was not.
The contract was not renewed.
I shall place my lord. Well, this is the judgment, my lord, which was referred to later also. Your losses may just see 59 to 65 and 87 into paragraph. 2014 9 SCC 40. Para 59 to 65. The other judgment were referred to here. Employer. But mainly your losses may come to my lord here, which have come. 65. That in this judgment they have concluded. Earlier, other judgments were referred to from 59 to 64, then 65 my lord, at page 400.
Yes.
Thus, it is can be concluded that relevant factors to be taken into consideration to establish employer-employee relationship would include inter alia, who appoints the worker, who pays the salary remuneration, who has the authority to dismiss, who can take disciplinary action, whether it is continued service, extent of control and supervision, whether there exists a complete control total. As regards the extent of control, person have only taken note of observation of strength. Well, they say that when the workers will be coming, they will keep the job my lord by the point of it, my lord. To that extent, these judgments are. Now, my lord, paragraph, my lord, now your losses may just see 57. In our considered light of issues going to hijack case, control have nothing to do with the appointment decision removal. All that control, my lord, only to that extent. Nothing to. This judgment was followed, my lord, in the subsequent case, 2019, 30 SCC page 82. Paragraph 22 to 24, my lord, that the control and supervision has been defined, my lord, from Bengal Nagpur cotton mills case. Then at paragraph 24, my lord, this judgment has been done. And my lord, there are 26 also, my lord, your office may see, actual place to have more judgment also. Pointed out in calculation and paragraph 26.
Yes.
So the proposition of judicial review by the High Court under Article 226, particularly when it was asked to give relief of a writ of certiorari, it is well recognized limits that mere errors of law or fact are not sufficient to affect the jurisdiction of the High Court under Article 2. There is no doubt that the law laid down by judgment is unexceptional. We may state that judgments have no application to the effect of the present case, labor court or the perverse whatsoever, that must be perversive. And in this respect, my lord, I shall rely two more judgments. My lord, one is 2018, 12, 20, another is 19, 13,
On what proposition?
On this, my lord, the jurisdiction of the High Court. Not, my lord, that's 1932, yes, I'm sorry, my lord, 1812.
They give a judgment against you yourself.
No, not against. They're already placed, my lord. I'm sorry, there are two copies, my lord. That is why I think it's taken. That has already placed.
Para?
Well, this para, well, the para 3, my lord. It's called that. Having record to documents produced by the High Court was not satisfied. After all, industrial terminal looked into the entire material. Unless the approach is only perverse, there must be perverse. In the sense that terminal acted on no evidence, High Court and Article justified. It will not just take for the first service.
2018, 12 SCC.
But
620. Para 3.
it's fair. So, my lord, my humble submission is that there is no perversity, my lord. and they fail to show the employer-employee relationship here, my lord. And the definition of contractor, my lord, fan is relied on. The last portion has not been, my lord, placed. It says that who supplies contract labor for any work. Where? Who supplies contract labor for any work.
Where, which,
Definition of contract, contract.
in that, definition.
That is. So, my lord, here, my lord, they fail to show anything, my lord. There is no capacity in that, award of the planner. This is why, my lord, all of this.
Page 31. Page 31, 31. Is there written statement? Paragraph 70. Therefore, it should be say main judgment is non-perennial in nature. In their WL, ONGC has various stores and go down in the eastern region where the materials of many kinds required by it in its activities of oil exploration received from the supplier store. These materials need to be tagged, shifted, and maintained. The work entrusted by the ONGC to various contractors. As the volume of the food, that is their own statement. Page 31, para W. Number, you have to come to page 64. But this is the judgment passed by the honorable court while remanding this matter. Yes, I will only one paragraph of this judgment I will write. Page 64, paragraph 4. Before the learned tribunal, Guwahati, evidence was adduced by both the parties to claim the reinstatement and regular exempt department relied on the report of Hasan the Assistant Labor Commissioner Central, who upon inquiry conducted that the service discharged by the workmen were perennial in nature in ONGC. The direction given by this court on 24/8/98 in civil rule number 3366/1995, Exhibit G, was also relied upon by the workmen in support of their claim. It was further projected that the labor contractor Tuliram Pupar secured his contract license only on 29/9/1989, Exhibit A, under Section 12 of the Contract Labor Regulation and Abolition
We have
Act.
read this, we have already read this earlier. Reading it right.
Then Miller, you'll have to come to page.
You see, another thing, with this case, the respondent counsel has said that the consequence of not being registered earlier can only be dealt with by the contractor paying a penalty, that's all. Nothing else.
Yes, no, so but whether it is a paper arrangement or not, that's what factors have to be considered. It may be one of the factors. It is not this whole factor. That has been observed by this portal.
So how do we know? Where is the evidence showing that there was a paper arrangement? Where is the evidence that would prove that it was a paper arrangement?
One thing is that, Lord, the contract labor, engagement of contract labor was abolished.
Was?
Exhibit W.
Ah.
Contract labor was abolished.
Abolished, yes,
Full.
yes.
Now, that abolition was made in the year 1994, 8/1/1994.
Correct.
And the contractor, this engagement of the contractor was continued. So,
And then you left when? When was the service terminated?
1995,
When?
in the month of June. July.
June 1995. So, till, and the abolishment of that contract labor was from when?
8/1/1994.
8/1/94.
And prior to that, was from 85 to 89, 1985 to 1989. That
No,
was-
but then that contract abolishment, that act only abolishes contract appointment of this engagement of contract labor for those who do not have license.
No, not only that.
But for those who have license, what happens?
Those who have license, for them also can be abolished.
No, it
But that-
can be is a different thing. But as per the act, the contractors can engage contractual laborer. In 1995, those contractors who have the license, as per section 12, they can engage contract laborers or not?
Taken 1995 taken.
They cannot. So till 1994,
Yeah, you're right. It is right.
January only they can.
Ah.
Is that a fact?
My lord, that notification is in respect of my lord storekeeper.
Oh, that is the storekeeper.
That is not.
Okay, for storekeeper. That is for storekeeper. That is for storekeeper.
That is, tribunal has also considered this.
It is for storekeeper, not for a.
For the other labor.
Okay, what job were they working as?
My lord?
Were they working as storekeeper?
No,
Huh?
no, my lord. They are only laborers, my lord. Getting the goods
They
from
are
here.
keeping the, they're keeping the store by lifting. They're assisting them.
That has been considered by
And
the.
there is contract.
He's harping on the same thing.
Yes.
No, I'm not. Really. Number another thing. Number page 64.
Yeah.
Look. On page 62, I've shifted it. Now your lordship may come. Page 1626.
Page 126. Yes,
Pen was 126 oblique 127.
yes.
MW1. Paragraph 14. Award itself, sir. The gist of the evidence of the management side is as under. They examined 3 witnesses. MW1, the Ranjit Boyagai, the manager in rank, stated that the contract workers were engaged by the contract. That is correct. To execute certain work, namely lifting, shifting, cleaning, stacking, and preservation of materials in product.
Correct.
Opening boxes, inspection. If who the contractor exhibit 1 and 1A. Exhibit 1 and 1A. He also exhibited the work order exhibit 2 series, wherein the jobs mentioned were the same as in the tender exhibit 1. He also proved the bill that is not required. Now, your lordship will come. One thing.
This is not in your favor. This is not in your favor.
Yes, it is in my paper.
How?
Job performed by them.
So job performed by them, what job? Lifting of boxes,
Lifting
shifting
of boxes, stacking of boxes, arranging the boxes, all the,
Store-
all jobs. are
storekeeper,
pertains
you
to
know, what is the job of a storekeeper?
all these things, to supervise all these things.
It is recording. It is recording of it is recording of the material. Storekeeper job is that. You see, storekeeper in say FCI, he is not going to carry the rice bags, 50 kg rice bag from here to there, shift it here. He is going to record. Storekeeper job is that. Storekeepers, they've got Maruti cars and all that stuff. They will not do the job of a laborer.
I am not saying that all.
So storekeeper's job is not lifting of boxes and
Yes,
storekeepers is they keep the accounts.
he is to supervise the jobs.
They supervise, they keep the accounts,
Keep the
basically the job. Yes.
But the contractor himself was a storekeeper. That is the problem.
Where is the evidence?
Yes, that is the here,
No?
page 126.
Yeah.
Para 14,
Yeah,
gist of the evidence
yeah,
of the management find was as a.
yeah,
They examined three witnesses.
yeah,
MW number 1, Ranjit Boragai,
yeah,
a manager in rank,
yeah,
stated that the contract workers were engaged by the contractor
yeah.
to execute certain work,
Namely,
namely
lifting.
shifting,
Lifting.
cleaning, stocking, preservation of material to go down, opening box, inspection, if who the contract tender exhibit 1 and exhibit 1. So he
Let us see this. What is the job specification? What is this exhibit 1 and 1A?
saying
Lifting.
lifting, shifting.
So what is the job? What is the job profile of a storekeeper? Lifting, shifting, everything.
No. Storekeeper's job is defined,
Then
and the storekeeper cannot be a contractor.
correct,
That is by contraction.
correct, correct,
And if he cannot be a contractor,
correct,
then he cannot engage the contract laborer.
correct. But then, no, the issue is
If
whether the lifting and shifting of boxes is the work assigned to a storekeeper. Is the storekeeper supposed to
no,
lift?
storekeeper he will not execute the work of lifting.
Then what will he
He
do?
will not execute the work of shifting.
Then what will
Or
he
he
do?
will not execute the stacking.
Yes.
But he will supervise all these things. By writing, he will come through a Maruti van.
Okay, so he's supervising.
Supervising.
So these contract laborers, they are not supervising.
No, they are not supervising, but the job of contract supervising storekeeper is vested in the contractor. That is the point I am repeatedly shutting up. Because it is evident from the evidence itself.
Just a minute. Sealed tenders are invited from registered contractors for execution of the following. These works, the shifting, lifting, cleaning, opening boxes, lifting. So this does not say that this name of job is not for storekeeping. It is for lifting. Then-
Lifting in the store.
Maybe. just because a helper, casual labor, starts working in a medicine shop, pharmacy, lifting boxes, opening the boxes, that does not make him a pharmacist.
No, I am not. Look,
So
I am absolutely with your lordship. Well, lordship, you is that these laborer for whom I am appearing before your lordship, they are not storekeepers.
correct. They are not
That is,
storekeepers.
they are not storekeepers. They cannot be a storekeeper.
They are not doing the job of a storekeeper.
They cannot do the job of the storekeeper, but they are assisting the storekeeper.
Correct. That is all right.
That is
That is
allowed. They are assisting the jobs of storekeeper.
the helping
And the
storekeeper.
keeping job
Huh.
has been vested the contract. That is evident from this evidence. We are
No,
evident.
no.
Now,
If
is
you
at
see,
stake
if the labor is assisting the storekeeper, then it will have to be assumed that the contractor is assisting the storekeeper.
Contractor.
You
we
cannot,
talk-
you
talk
cannot
of-
assume two different things for the same, because what you're saying, on the one hand is the contractor and the helper is the same, and the
No,
contract labor is the same.
No, no.
They're the
contractor-
same. That's what you're saying. The the contractor cannot be a storekeeper. Accordingly, the contractor cannot appoint this contract labor to do the work of a storekeeper. You're correct.
They
Similarly,
cannot- Yes.
similarly,
Your Lordship.
if the contract worker is helping the storekeeper, then it can be assumed that the contractor is helping the storekeeper. He doesn't take the place of he doesn't fit into the shoes of the store. Anyway, what we'll do is, Mr. Dasgupta, what I'll do is, I'll start dictating, I'll write down everything, then I'll give you a chance to reply again, so that while I still everything is little bit still fresh in the mind, I'll give you a chance to reply, so that on the next date, if you want, or today itself, we'll complete everything. So I'll
No,
start
as
dictating.
your Lordship deems fit.
Huh?
As your Lordship deems fit.
I think better.
But
Otherwise,
then I.
you will not finish your submissions, I think. Okay, right. Heard Mr. A. Dasgupta, learned senior counsel for the petitioners, assisted by Ms. B. Das. Also heard Mr. G. N. Sahawala, learned senior counsel for the respondent. Respondent number
20.
Point number 2 and 3. Assisted by Mr. M. Sahawala. Wherever I make a mistake in the facts, please correct me. The petitioner, the petitioners have put to challenge the award dated 11/7/2019, passed by the Central Government Industrial Tribunal cum Labor Court, Guwahati, in reference case number 3 of 2016. Wherein the learned tribunal has dismissed the claim of the petitioners to be reinstated into service and regularized, on the ground that there was no employer-employee relationship between the petitioners and the respondent number 2 and 3, that is the ONGC. The brief facts of the case is that no, the case of the petitioners is that the petitioners had been the petitioners were engaged directly as contract laborers by the ONGC in the year 1985. And later on, they were engaged on contract basis through a contractor. That is Mr. Tulu, huh? Tudi Ram Fukan. How do you spell his name? T.N. Fukan. T.R. Fukan. T.R. Fukan. huh? In terms of the, and that's all. That's in terms of, huh? As the petitioner, no, the stand of the petition, the engagement of the petitioners on contract basis with Mr. T.R. Fukan on a later date was only a paper arrangement which sought to camouflage the fact that the engagement, the direct engagement between the petitioners and the ONGC still remain. Full stop. The petitioner's case is that as they were directly engaged by the ONGC from 1985, they no. The first case is that you were
They were directly engaged. And
No, no.
subsequently they were
you were terminated in 1995. Why?
disengaged.
Disengaged by
Disengaged.
no. What have I said? No, before direct engaged. Correct. No, before that. Just read the entire thing. Full stop. The petitioners were thereafter. The petitioners were what the petitioners were disengaged by the ONGC in the year 1995. Then you write that. Then that paragraph. Huh? Then what will be the next paragraph? Just read. The last. Yeah. 1985. Till there,
Subsequently proved the contract labor.
till the disengagement in the year 1995, their services should be reinstated and their services regularized with the ONG. Full stop. Next paragraph. Then what happened? Then after that, you all went to the,
I put before this honorable court.
you came directly to this court.
This court directed to
As the prayer of the next paragraph, as the prayer of the petitioners was not being considered by the ONG, the petitioners approached this court by way of civil rule number 3366/1995. This court, by order dated 24/8/1988, held that as it was not possible for the court to make an order for regularization of the concerned workmen as regular employees of the ONGC, comma, the better course would be for the petitioners to approach the ONGC, comma, who no, to ONGC to examine the matter in the context of the correct factual position made in its records. Huh? No, that was it. This finding of the, this observation of this court in the order dated 24/8/1998 had been made due to the fact that the ONGC had denied that the petition had denied the stand taken by the writ petitioners that they were contract laborers of the ONGC. As they were in fact engaged by the contractor of the ONGC for supplying manpower, comma, that is Mr. T.R. Phukat. Next para. No, next para. This court, in its order dated 24/8/1998, passed in Civil Rule number 3366/1995, held that ONGC, being a public undertaking, was supposed to do things in keeping with the provisions of the Contract Labor Regulation and Abolition Act 1970. And as desired by the counsel for the petitioners, comma, the matter was left to the better discretion of the ONGC authorities to pass appropriate orders, comma, after examining as to which of the petitioners could be given the status of an employee of the ONGC. This court further held that in case the petitioners still felt aggrieved, comma, they may approach the labor court for appropriate relief in accordance with law. Full stop. Next para. Then what happened?
Then there is an industrial dispute.
Before the ONGC. No,
we-
you went to the ONGC first.
We approved before the labor commission.
No. In terms of this order passed in civil rule, you have to go to the ONGC first.
Yes, we went to the wing.
Where is the rejection of your prayer by the, is there any nothing?
None, they
Okay.
were not considered.
Then after that, you went to the Labor Commissioner,
And labor commissioner for raising this industrial dispute.
Central Labor Commissioner.
Central.
Okay, for it.
Existing-
Next para, you're right. The petitioners thereafter approached the ONGC in pursuance to the order dated 24/8/98, passed in civil rule number 3366/1995. As no decision was forthcoming in favor of the petitioners. The petitioners approached the Central Labour Commissioner, Guwahati, with a prayer for raising an industrial dispute against the ONGC regarding the petitioner's claim for reinstatement and regularization. Then what happened?
That was referred to the industrial tribunal.
That's a conciliation effort.
Constitution held, then constitution failed, and the
Full
matter
stop.
has been referred.
A conciliation proceeding was held, and as nothing could come out of the state, the matter was referred to
Central government,
the central government.
Industrial Tribunal Guwahati.
Huh?
First Industrial Tribunal Guwahati.
central government for making a reference.
The matter was referred to the central government for making a reference.
Central government referred the matter.
The central government thereafter referred the matter.
Before, well, one thing, before the industrial tribunal, state industrial tribunal at Guwahati. Because at the relevant point of time, no central industrial tribunal at Guwahati.
Okay, before the state industrial tribunal, Guwahati.
At that time,
And where is the reference?
Well, that page 50, my lord. Page 5.
Page 50. With the following reference, with the following issue to be decided. Inverted commas, we call the next one. Whether the services of the workman, bracket list and close, bracket close, working directly under ONGC management in the first phase of service and later engaged on contract basis can be reinstated and regularized. Question mark. If so, comma, to what relief they are entitled? Inverted commas. Now you go.
one thing that can be clarified if you also desire to do so. At that point of time, there was no central government industrial tribunal at Guwahati.
No.
So the matter was referred to the state.
I know. Then what happened after that?
The industrial tribunal passed an award. Guwahati.
The
Passed
state
an award.
industrial tribunal passed an award.
Passed an award.
There was
Was
challenge,
partly in favor of the workmen.
partly in favor.
Workmen.
And
And then,
three workmen.
And there are 3 out of the 22 workmen.
here of the tribunal. So we approved before the High Court. They also
Okay.
approved before the High Court.
The next para. The matter, the dispute between the industrial dispute raised by the petitioners had been referred to the state industrial tribunal,
And because that
Guwahati. In view of the fact that at the relevant point of time, no central industrial tribunal had been established at Guwahati.
no central industrial tribunal was established.
No central,
Industrial tribunal.
that's
was-
what I've said. That's what
At that point of time, no central.
that's what I've said.
Oh, yeah, sorry.
Had been established at Guwahati. Full stop. Next para. The industrial tribunal, no, the reference case,
Well, page 60, my lord. Last paragraph. Page 60, the last.
Award was passed on 31/12.
the reference case was registered as reference number 8 bracket C of 2000 before the State Industrial Tribunal Guwahati, which passed its award dated 31/12/2005. Wherein it partly allowed the reference in favor of 3 out of 22 workmen. Full stop. The
Page 63.
next,
Page 60.
being aggrieved by the award dated 31/2005, passed by the State Industrial Tribunal Guwahati in reference number 8 bracket C of 2000, comma. There were two repetitions.
Yes.
The ONGC put the same to challenge.
Five double.
The ONGC and the petitioners put the same to challenge by WPC number 5446/2006 and 2139 2139 of 2008.
2008.
2008.
2139.
2008.
2008. This
Good
is
stuff.
page
Ah,
63.
next para. Respectively, yeah, respectively. Both the above writ petitions, no, continue, both the above writ petitions, oh, you make it, next para, both the above writ petitions, that is WPC 2139 of 2008 and 5446/2006 were disposed of by the common order dated 4/9/2015
Page 81.
page
81.
21.
81. That's it.
Oh. Paragraph 22. no? Okay.
by holding that a perverse award was given by the learned industrial tribunal, comma, since relevant evidence was ignored to deny relief and inference was drawn on the basis of inconclusive and inadequate material. Full stop. The case was remanded back to the learned tribunal for a fresh decision by taking into account the existing and fresh evidence as may be adduced by the party. Next part. The case was thereafter remanded, no, the case was thereafter remanded to the Central Government Industrial Tribunal cum Labour Court Guwahati in pursuance to the order passed, common order passed in WPC in view of the fact that the Central Government Industrial Tribunal had by then been established in the state of Assam, in Guwahati, So the matter, when remanded back, was also given a fresh number. That is reference case number 03 of 2016. Then fresh evidence was taken by both sides.
Yes.
Full stop.
There's evidence on their side. We have not given more.
Okay.
Our earlier evidence.
Okay, full stop, huh? In reference case number 03 of 2016, fresh evidence was taken by the writ petitioner. And the same was disposed of by, where is that order?
Page 116, 115.
Was disposed of by award dated 11/7/2019. by dismissing the petitioner's claim for reinstatement into service and regularization on the ground that the petitioners slash workmen failed to prove that there was employer dash employee relationship between the ONGC and the work within the meaning of the Industrial Disputes Act 1947. Being agreed, the writ petitioners have preferred the present writ petition. So that has been covered, I think. Now, the petitioners counsel submits that the petitioners had been directly engaged by the ONGC in between the year 1985 and 1986 as contract laborers, as laborers. That is even before the contractor, Mr. T.R. Fugger, was registered as a contractor under section 12 of the
License. Take license.
was registered as a licensed contractor under section 12 of the Contract Labor bracket Regulation and Abolition bracket close Act, 1970. Herein after referred to as the Act. The Act. Yes, sir. The petitioners counsel submit that the ONGC had already been established, had already been registered under section 7 of the Act when the petitioners had been engaged by the ONGC. As the contractor did not have a license, did not have a contractor's license in terms of section 12 of the Act, during the years 1985 to 1989, 1988, 1988. 89 he got it. 88 he got, till 88. Till 88 he did not have. And 85 to 88, comma. The subsequent engagement of the petitioner as a contract laborer, under the contractor was only a paper arrangement. Paper arrangement, that's not the correct word. Only a, with, huh? Was only a, was only a, was only a, was only a paper, was only a, was only a veil to camouflage the fact that the petitioners were employees of the ONGC. Next one. What is that exhibit F? Acha.
Still Labour Commissioner.
Still Labour Commission report on the basis of,
The order passed by this honorable.
in which the first
Judgment.
judgment, APC judgment.
Yes.
Full stop. He submits that the Assistant Labour Commissioner had made a report in pursuant to the but this order does not say that Assistant Labour Commissioner.
Prior to that, the interim order was passed, directing the Labour Commissioner. Subsequently, the report is submitted, then final order.
Okay, this is the final order.
Right.
Okay, he submits that. In pursuance to the interim order dated. Is it here? In the. You see, that is why I need all the facts. So it will be clear.
That's all. Okay.
He submits that prior to the order dated 24/8/98 passed it. Civil rule number 3366 1995. This court had passed an interim order directing the Assistant Labour Commissioner Guwahati,
Central.
the Central Assistant Labour Commissioner Guwahati, to make a report. To make what report?
About the status. To make an inspection, to conduct an inquiry and submit a report
With regard to what?
about the status of the contractor.
Contract- To conduct an inquiry and make a report with regard to the status of the workman or slash petitioner. The report of the Central Assistant Labour Commissioner was exhibited,
Which
It- exhibit F
dated 5/1/98.
in the last case, in reference case number 03 of 2016. Which showed that, which stated that, where is that page? In HIF? Do we have it?
Yes. Okay.
That is why I need y'all, because now if I had left it, and to make another order
Yes,
later becomes difficult.
In the record also there.
No, I will, well, it's so thick, I'll have to look.
That's why I have to segregate.
I will check that later on.
Oh.
What does it say basically? What does it say basically?
These workers are engaged in the year 1985.
Ah.
And they are performing perennial nature of job.
Okay.
They are performing perennial. Subsequently, they were shown as the contract laborer
From when?
from 1989 or 19.
And what about the contractor? Did he say anything about the contractor?
No.
So
Internal page 2.
but there are two types of contract workmen out here. It says
One is typist.
there some of the workers out of the list of 22 didn't work in two spells. Two spells. What have I said? We stated that some of the 22 workmen worked in two spells. So firstly, under direct payment system till December 86 from the ONGC, and with effect from January 87 to March 96 under the ONGC contractor, Mr. T.R. Pukan. That's all.
The word a page, internal page 3. The worker of the perennial nature, that was also.
Okay. Further,
Jobs of loading and
Further.
handling.
further, the job of the job profile of the workman was for loading, unloading, handling, as well as no typing will not be
Typing
there.
now here. And the
And handling, huh? Which appeared to be
perennial nature of job.
of a perennial nature of job. That's all. Next. What about exhibit W? What is that? I think, my lord, open.
Abolition of contract labor.
In respect of the
ONGC.
Where is that? Where is that page?
page 12.
No, it is here in the writ petition also, I think.
No, but exhibit is not there. Document. Item number 17. Item number 17. I'm just giving it here.
Page 16, page 17.
Item number 17. Notification dated 8/1/1994. Item number 17.
The petitioner's counsel further submits that in terms of the notification dated
8/1/1995.
8/1/1994
1994
issued by
by the government of India
the government of India
in exercise of their power conferred under section 10.
in exercise of the powers conferred under section 10 of the Act, comma, the
Item number
work/job prohibited
ONGC.
under the ONGC also included the work of storekeeper. He submits that the writ petitioners / workmen were doing the work of, were assisting the storekeeper, assisting the storekeeper. And the contractor was the storekeeper.
No. That is my argument. That is my argument whether you are not by through MW1 it appears.
But where have you said that the storekeeper was the contractor? No, there's no.
Just MW1.
It says that storekeeper, but
No,
contractor is not a storekeeper.
okay.
What?
I just now pointed out.
I don't know.
The evidence of MW1.
Not read that much.
No.
Your lordship must just see page 126.
126.
126, there 14. My
Oh,
lord,
yes, 126.
Yes,
there 14.
yes.
That
I have relied upon this.
Where?
By manager
Huh?
Jeng.
Huh?
Para 26, para 14.
Yes.
Yeah, sorry.
126. He has not said that, my lord.
That is the statement of MW1, the Ranjit Boragohai, the manager in the rank, stated that the contract workers are engaged by the contractor
Correct,
to execute the certain work,
Correct.
namely lifting,
Correct.
cooking, cleaning.
correct. But he's not the storekeeper. That is the wrong topic. Whatever I said. A storekeeper. He accordingly submits that as the profile of work done by the workman is reflects upon the work profile of the contractor. The contractor could not be doing the job of a storekeeper.
What's the kind of engagement? Anyway,
What have I said? The last question, the job profile of the the contractor could not engage contract laborers for doing the job of a
for the doing of the job of store.
for doing the job relating to the work of a storekeeper.
Letting the store, let it be fixed.
Relating to the store, relating to the store which was supervised by the storekeeper. Actually supervised by somebody else. Stop. Then what else? That's all. According to full stop. The next paragraph, the petition council submit that in view of the reasons stated above, the petitioners would have to be considered to be workmen engaged by the ONGC and their services should be reinstated and regularized.
Just the tax product, tax of
Next paragraph. Mr. A. Das Gupta also relies upon the judgments of the Supreme Court in the case of
Hassan Bhai versus Allah Factory Union reported in KIR 1978 ST 1410. Para 5.
In the case of Hussein Bhai, Calicut versus Alat Factory Sensor 1978, 4 SEC 257. In support of his submission that when a worker, when a group of workers produce goods or services for the business of another, that is the employer, the presence of intermediate contractors with whom the workers would have immediate or direct relationship is of no consequence. If the lifting of the veil discerns the naked truth that the real employer is the management and not the immediate contractor. Yes, what do you want in this 2001 7 SEC?
That is when the contract labor engagement or contract labor is the paper arrangement that the employee to consider the employee.
So it is same as this Calicut. Similar.
It is also said in the contract.
Similar thing.
Like,
It's similar. Out here also same.
and in each judgment, this was also required.
So okay. You just say in the case of that Calicut thing and in the case of this one. The 2001 7 SEC
Page one.
page page one. Okay. The Supreme Court. So I mean the same thing it has said in both.
Almost same thing, but they
Almost.
detailed there.
Huh?
Almost
It
same
is
thing, but
basically the issue is same. That when you lift the veil,
yes,
actually the thing is that when it can be seen from in the naked truth shows that actually it is the employer who has engaged, then that the
Yes.
intermediate contractor issue does not come into the. Okay, then the next one would be
similar line of that.
all four same.
Almost more or less. Like, only thing is the factors to be considered. Defined factors to be considered.
No, that we will
Next
see.
similar item will have.
I just want to see.
But right now, they just don't write this citation.
For stuff, he has also relied upon
But that will
the judgment of the Supreme Court in the case of Gujarat Electricity Board, Thermal Power Station, UKAI, UKAI, Gujarat versus Hind Mazdoor Sabha and others. 1995, 5 SCC, 27. Wherein it has been held that if a contract is a sham or not genuine, the workman of the so-called contractor can raise an industrial dispute for declaring that they were always the employees of the principal employer and for claiming the appropriate service condition. That is the word I wanted, sham. Not paper agreement. That is the labor code has said. But that is not the correct use. We can understand the way, with little bit of facial expression, we can understand what you mean. But then it's not the correct use of the word. Anyway, right. Then next will be. I don't know if this judgment is in your favor. 1999-3. You want this? Huh? It's the same thing. So don't put this. This is enough. Don't.
There is no hard,
Same again, lifting the veil
no, no,
again.
there is no
Next.
hard and fast rule in
Next
what
para.
manner the
Yes.
veil should be lifted.
Yes, yes,
It depends upon the facts and circumstances of this.
correct.
That is also observed by this court in this case. Honorable Justice Ritik. Yeah, here in the district.
Anyway, we'll see. Right. Right. Mr. G.S. Sahawala. The learned senior counsel appearing for the respondents number 2 and 3. On the other hand, submit that the notification dated 8/1/94, which has been made in exercise of section 10 of the Act, prohibiting a contractor from doing the duties of a storekeeper, is not applicable to the case in hand, in as much as the petitioners have not been working as storekeeper. He further submits that what else did you say?
Well, two judgments I have placed, my lord.
He further
2018-12 SCC.
he further submits that the he further submits that the jurisdiction of a high court, while considering an appeal made, while considering a challenge made to an award by the industrial tribunal, is extremely limited. In this regard, he has relied upon the judgment of the Supreme Court in so and so 2018-12 SCC 620,
Then the another is 19.
wherein it has been held that unless the industrial tribunal had looked into the entire material No, unless the industrial tribunal,
Except for no evidence.
no. Unless the approach of the industrial tribunal was wholly perverse, in the sense that the tribunal had acted on no evidence, comma. The High Court under Article 226/227 would not be justified in interfering with the award. Comma, in as much as the High Court was not a court of first appeal to reappreciate the evidence. Ustad.
Same point, well, 1913 SSC 82.
Acha. Then you say, in the case of Penso and 2019 13 SEC, okay. Then there is one more. Next.
Then one judgment I have told my lord regarding the license. 1992, one at 56.
Next, you're right. The learned senior counsel for the respondents number 2 and 3 further submits that the Supreme Court in the case of Balwant Rai Saluja and another versus Air India Limited and others, 2014 9 SEC 407
Paragraph 65.
has held, has indicated the relevant factors to be taken into consideration to establish an employer-employee relationship which are as follows. Para 65, 1, 2, 3, 4, 5, 6. Small. Okay. 1, 2, no, one line. Para 65. And you said about that,
Same
that
word relied in
1992.
1913 also, my lord. Same word relied in 1913, SSC 82 also. The Balwant Rai.
Why one is enough?
No, then another case followed that
1992.
92 one SSC.
Next. Mr. James, the learned counsel for the respondent, numbers 2 and 3. Further submits that even if the petitioners had been were they initially engaged? No. Were they initially engaged with by the, no, they were not. Submits that. Though the contractor, Mr. T.R. Kukan, had been given his contractor's license in terms of section 12 of the Act in the year 1989. The fact remained that the contractor had been the manpower supplier from 1985 from 1985. Thus, the act of the contractor would not, thus even if it is assumed that, that's the act of the contractor at best.
Take provisions of section 23, 25 of the Act.
Would at best attract the provisions of section
23 and 25 of the Act.
23 and 25 of the Act. And the same would not amount to making the ONGC the employer of the writ petitioner slash workman. Correct?
Yes.
So I've referred to this judgment, no? 1992 one, I've given you the, oh, I've not said, but in this respect, he has relied upon the judgment of the Supreme Court in the case of Dina Nath and others versus Dina is DENA versus National Fertilizers Limited and others, 1992, 1 SCC 695. Pustak. He further submits that the evidence adduced by the workmen show that no appointment letters had ever been issued. No appointment letters or salary slip had ever been issued to the petitioner to show that they had been directly engaged. No, salary slip issued by the ONGC had been issued to show that, to prove that they were directly engaged by the ONGC. He submits that. That's all, anything else?
That only thing that itself of the gate pass is only place where if anybody enters, he requires a gate.
Full
So
stop.
that
He also submits that the issuance of a gate pass to the workmen, to the petitioner, does not prove that they were. Huh? Does not prove that they were directly engaged by the ONGC. As
written there
as each and every person who enters the ONGC complex is required to have a gate pass. Full stop. Further, they were working for the ONGC on the basis of the manpower supplied by the contract, by the license contract. By the contractor, just say by the contractor, by the contractor. He accordingly submits that as there is no infirmity with the impugned award, the writ petition should be dismissed. Now I have recorded both your submissions. Any more, no, any submissions to make, further submission? Or is enough? Tomorrow. No, I don't, tomorrow I've got no time.
On Monday.
Monday,
Roughly one to
we have,
5 minutes.
you take 5 minutes.
No,
How much time will you take? You see, the thing is that I have recorded all this because I want to finish it. But I don't want you, you see, the thing is that, you see,
If anything left, I will not take more than 5 minutes.
okay, please keep it in mind, 5 minutes.
5
5 minutes.
I shall try my level and do it.
Monday.
Because almost everything I have.
You think we have got all those big ones? TK Goswami, all those.
This order will.
We have got lot of fixed matters, no? That's the problem. All these, all the councils are ready to do the matter. That's the problem. Yeah. It's not that they are running away. The problem is that they are willing to do the matter.
Yes.
So that's why the thing is that time is the problem.
That is also my engagement.
Huh? You can do it now. I can hear you now.
Only 5 minutes. Next,
I can give you 10 minutes also, 15 minutes also now.
come for homework. Only 5 minutes. You have to record it.
Okay, 5 minutes to try and finish. Huh? Next time.
Record it. Okay.
What?
If required.
Okay.
No, I'm giving assurance. I'm not.
Okay, we'll try on Monday.
I shall try to give a written note on it, so that it may not take.
Tomorrow, no. Tomorrow,
All that,
if you
any
can,
day, Monday,
if you want,
before
if,
vacation.
yeah,
Before
yeah,
vacation, any day.
You can write it down, you can give me a small, that extra points, don't make new points.
No, no, no.
All right.
All
You can give me a written thing also. Because basically I understand, I've understood your case, I think.
Yes, yes, sir.
I think the facts are all right, both of you.
More or less fact.
Facts are facts, so now the only thing is that I've got to take a decision, either this way or this way.
So I'm just placing my mind, opening my mind, but I will try to impress your lordship that the job of the contractor, a worker, to assist the contract,
Storekeeper.
storekeeper, is the-
Okay, that storekeeper, that is at what page, storekeeper job you're saying?
this much I will,
I give it W, my lord,
the W.
I give it W, they, my lord.
Only the three, handling, shifting and all, only that.
That is in the tender also,
Exhibit one and exhibit 1A.
that is there.
Where is that exhibit 1 and 1A?
And it is in paragraph 14 of the award also it is there.
Okay.
I
Paragraph-
will try that.
Just say I have heard the learned process for the parties, then paragraph 14.
14.
The
I will try to your lordship.
The examination of fee,
Yes.
what is MW? MW is,
Management witness.
Management.
that is your witness.
My witness said, my lord, that from the.
Earlier with,
Yes.
the, what have I said? The examination of the management witnesses show that the petitioners who were engaged to execute certain works, namely lifting, shifting, cleaning, stocking, preservation of materials in go down, opening of boxes and opening of boxes for inspection. I just put that.
I will not.
Okay, list the matter on Monday. You just say heard sensor and heard sensor. List the matter on Monday as part heard. And then this you type out. Because this will have to go today itself. This you give back. This also have to be given back. What? Only. We can, but I think we can give it back tomorrow. So he'll need it for typing, no? I don't need it.
That
I
is better
want,
Monday.
huh?
Monday will be better.
That's what I said, fix on
Monday
Monday.
will be better.
I take this. Should have fine. Okay.